Good evening, chat. Hello, everybody. Hi, guys. Welcome to today's Tuesday. Yes, Tuesday night. Welcome. And yes, there's a Clyde sighting. I know you guys wanted to see him. Hi, buddy. Look, what are you freaking out about? There's nothing back there. He's like, let me see over the shoulder. Anyways, guys, hello. My name's Potentially Criminal. I'm a defense attorney in the Cleveland, Ohio area, also known as Sean, and we are getting ready to cover the Garland v. VanDerStok oral arguments that happened today. And since you guys keep on wondering what the heck, this is one of those peens that he keeps eating. These are like smoked and not like the kind Nick likes, but smoked bull penises that get all like dehydrated and rolled up, and then dogs could chew on them. The problem is if they chew the whole thing, when they get to the end, they choke on it. So they make these things here so the dog can't eat the last part and chew on it. And Clyde is being fucking... What's wrong, buddy? Hey. What are you doing? What are you doing? I don't know what the fuck he's doing, so I'm going to put him down and let him go because he's being a spaz, and I can't... He's like 22 pounds. He's a bit of a hog. Hey. Mwah. You got anything you want to say tonight? Anything you want to say? You're such a good boy. Anyways, guys, I know Clyde's been hiding out from us, so I wanted to show you. Guys he's doing okay and he's living his best life. So you ready to get down, Bubba? Huh? You want to get down? I got you. All right. Here, don't forget this. Hey. Gotta take his peen with him. All right, guys. So, yes, we are covering Garland v. VanDerStok. The case of Garland v. VanDerStok is the issue about whether or not the ATF can put a rule out regulating that lower receivers and unfinished frames and parts, basically ghost guns, so spooky. Ooh. Very much like that guy right there, the P80 lower I carved out last year for Halloween, or an 80% lower for an AR-15, that those can be counted as firearms, and that firearms parts kits are firearms. That's a rule the ATF has put together. It was proposed back in 2022, and then in 2023, yes, the spooky ghost guns. And then in July 2023, a woman in Texas named Jennifer VanDerStok, she was a former police officer, and she was now a high school teacher, challenged the law along with a couple other people and some companies. And they did through FPC, the Firearms Policy Coalition, among other groups. They challenged it, and the judge agreed this is bullshit. From there, it went up to the Fifth Circuit, and basically the ATF was enjoined from enforcing the rule. What happened then is the ATF went to the Supreme Court and cried about it, and the Supreme Court lifted the stay. I mean, the ATF was not prohibited from enforcing the rule while it went through the courts. Not really a surprise. The Fifth Circuit pretty much agreed with the district court that this was improper. And now we're at the United States Supreme Court. Saying it's out of Kansas. No, this is not out of Kansas. Hey, Kurt. Potentially Criminal is doing an oral argument review of a SCOTUS case. I'm still infringing my trade dress. Get off my lawn. Yes, I'm stealing your work, Kurt. Got to report it to the union. Anyways, guys, Uncivil Law, Kurt, hope you're doing well. Give him a look if you guys haven't checked him out lately. Give him a like and subscribe as well. Does really good work over there. But yes, this comes down to the issue with the 80% receivers, guys, and the parts kits. And it's going to be funny because they're going to talk about... you're going to hear some comments from these people. And the justices do make some gun-related comments. They're still not the best. Remember, these are judges talking about guns. So that's where we have to start off with when we're analyzing this. But what I will say is a lot of people A lot of people have their own views on what they think is going to happen here or what's happened today. I didn't listen to it. I only listened to a couple minutes. There's some pretty good points in it. There's a really good... The ATF makes a lot of concessions, surprisingly, in this. But we're going to get into this today, and we're going to start going. Guns don't kill people, rappers do. Well, that's true. And yes, guys, right now, you can still get 80% receivers. You can still take them apart, cut them up, and make them work. You just can't buy the 80% receiver with the, as example, the Glock, with the trigger pack and the lower parts kit and a barrel and a slide all ready to rock and roll in one package and not have it labeled as a firearm. That's the biggest issue here. Kurt says, I've got your 80% right here. Yes. Now, the funny thing is, well, there's nothing stopping people from doing like 70% receivers or 79% receivers. People are getting better and better and better at how to make these, how to build them, how to set up jigs, how to refine them and manufacture things. So it's a game of going back and forth. It's cat and mouse, measure and countermeasure. So here we go. Let's get started. And we are using we're going to be using the feed from C-SPAN. I think it's got the best audio. And we're going to get started here. And we're going to stop if there's anything good to bring up. And the better thing about this is it's going to show who's talking, which I think, even though we don't have the closed captioning tied to it yet, this will help a lot about figuring out what's going on and who's talking about what. So here we go. And we'll try to do English. Anyway, here we go.
It's right that the 60 Minutes appearance is part of a Harris strategy as the Democratic president.
Oh, yeah, and there's the other part about, yes, Kamala Harris saying, like, I don't know if any law amendments, like the draft, selective service. And I do love that Kamala says she owns a blicky. And I'm like, I doubt you own a Glock. I doubt you own a Glock. Colin, no.
Presidential nominee to hit all corners.
Poses straightforward.
Anyways, here we go.
Media landscape in the final weeks before Election Day, from podcasts.
And it just goes right into oral arguments, guys, because that's just how it goes.
To TikTok, to talk shows, to local radio.
Gun Control Act imposes straightforward but essential requirements. Firearm sellers and manufacturers must mark their products with serial numbers, maintain sales records, and conduct background.
And if you guys don't remember, well, I don't think we've done this before lately. The Solicitor General is the person arguing on behalf of the United States and the DOJ and Merrick Garland. So this is the position. You get to go in front of the Supreme Court all the time because guess what? The United States government gets sued all the time and the United States government ends up in the Supreme Court all the time. So if you ever want a job where you get to go in front of SCOTUS a lot, this is like the job. Like Paul Clement, if you've ever heard that name, he's a very famous Solicitor General. He's argued in front of the Supreme Court a ton. And it's really annoying, though. The cringe part about this is the addressers general. That's the only part about this is really cringe.
Checks. The industry has followed those conditions without difficulty for more than half a century, and those basic requirements are crucial to solving gun crimes and keeping guns out of the hands of minors, felons, and domestic abusers. But in recent years, companies like the respondents here have tried to circumvent those requirements. They've begun selling firearms as easy-to-assemble kits and frames and receivers that require minimal work to be made functional. They've advertised the products, in their words, as ridiculously easy to assemble and dummy-proof.
Now, those are comments when you make those ridiculously easy to assemble and dummy-proof and anybody can do it. That's where you start, when your advertising can shoot you in the foot.
And touted that you can go from opening the mail to have a fully functional gun in as little as 15 minutes. No serial number, background check, or records required. Those untraceable guns are attractive to people who can't lawfully purchase them or who plan to use them in crimes. As a result, our nation has seen an explosion in crimes committed with ghost guns. In the face of that public safety crisis, ATF promulgated this rule to underscore 2 points about the Gun Control Act's plain text. First, a weapon parts kit that can readily be converted to function as a gun with common tools, often in under an hour, is a covered firearm. Second, a product is a frame or receiver under the Act, even if the buyer must drill a few holes or remove a few superfluous pieces of plastic to make it functional. Both of those points are consistent with how ATF has interpreted and implemented the Act across 5 decades and 11 different presidential administrations. Respondents now seek a sea change in the Act scope. They claim that if a firearm isn't 100% functional, if it's missing just one hole that could be drilled in seconds and immediately assembled into a working gun, that product can be sold to anyone online with no background check, no records, and no serial number.
Yes.
That contradicts the Act's plain text, and it also contradicts common sense.
That Act
This
is
court should make clear
unconstitutional.
that the Act regulates these products as what they are, firearms and frames and receivers of firearms. I welcome the court's questions.
Does this new
I mean, it's unconstitutional as shit. Oh, it's been law for 50 years. Yes, and it's a very horribly racist law. The Gun Control Act of 1968 was a horribly racist law, among all the other gun laws that are racist. It was also, ironically, a gun law supported by a majority of firearms manufacturers in America, because the prime purpose of the Gun Control Act was to limit imports of guns. And those were back when you could get, Mauser rifles for cheaper than a Winchester. So there are many reasons why the Gun Control Act passed. Also, the assassinations of the Kennedys, Martin Luther King, Medgar Evers, et cetera, et cetera, et cetera. But yes, there's it's been the law. That doesn't mean the law is valid. But that's what the government's running on.
regulation cover all of
Firearms
We'll
and
let
frames
we'll
and
let Uncle
receivers
Clarence
of
go.
firearms. I welcome the court's questions.
does this new regulation cover all of Chapter 44?
Yes, so I think that the understanding of a firearm reflected in the final rule does reflect the 922A13 definition.
Would it also apply under 924?
Yes, and so I think that also incorporates, though, Justice Thomas, the mens rea requirements that are under 924, which I think guards against some of the concerns that respondents have raised in this case, that manufacturers could unintentionally be swept up by these restrictions. For example, 924A1D requires a showing of willfulness with respect to selling products without a serial number or without a license.
Do you make a lot of the fact that this has been regulated for a half a century, but it wasn't regulated in this way for a half century? What was the original reg, the previous reg?
The previous reg defined a frame or receiver with respect to particular components that were housed in that primary structure. But Justice Thomas, I agree that this rule reflects any fundamental change in approach, because under that prior reg, ATF consistently recognized that even when that frame or receiver, the primary structural component, wasn't yet fully finished or complete, still it would qualify as a firearm, looking at the same factors that are listed in the rule. Things like, how much time is it going to take to make it functional? Do you need special equipment? Do you need to buy parts, and are they readily available? Do you need special skill? So all along from 1968 on, the agency has consistently focused on this same issue of how quickly you can make.
That's not actually true. The agency has flipped and flopped a lot about what constitutes guns, what constitutes machine guns, what constitutes ready convertible. I mean, they flipped and flopped a lot. They have not been consistent. Over the past 50 years, the ATF has done nothing you could call consistent. I mean, that's the funny part. She says that with a straight face because she doesn't know, but the ATF is not consistent, has never been consistent.
Make that frame or receiver operational as part of a working gun. And the only change in the rule, and I want to openly acknowledge this as the rule does, is that ATF is now taking account of jigs or templates, which are a form of tool that quickly speed up the process of making a frame or receiver functional, because they show you exactly where you have to drill in that weapon. So there's no trial and error or guess.
Yes, because we can't have, jigs and fittings, because we can't have the common populace learn how to manufacture weapons at a very quick scale. That would be too dangerous. Too dangerous.
Or templates, which are a form of tool that quickly speed up the process of making a frame or receiver functional, because they show you exactly where you have to drill in that weapon. So there's no trial and error or guesswork. But as ATF explained in the final rule, that wasn't a change in statutory interpretation. It was just a recognition that jigs serve precisely the same function as something like indexing, stamping the frame or receiver to show you where you have to drill. So it goes directly.
Now, that is true. That is, the ATF is making. That's the same as indexing, but indexing is different. So, guys, for example, on a lower receiver for an AR-15, You could draw on it the full auto receiver pin. You could draw on it, but you could not engrave where that was to make it look like you had a full auto receiver pin, because that was counted as an indexing point, where if you mark on the receiver where you have to drill through permanent means, that is an index point. You're showing people how to make it readily convertible. So the indexing is not the same as a jig or a fixture. Yeah, jigs or fixtures, yeah, you can only go through one spot, sure, but you can easily fuck that up still. I mean, this is just a continuation of their nonsense. So Ariel's saying she should really ditch the bangs. Are we mean girling this tonight? No, chat. Don't mean girl tonight.
To the question that the agency has asked all along, namely, how quickly, easily, and efficiently can this process be completed?
General, I'm looking at agency
I hate that name.
letters stretching back as far back as 1978.
General.
And each of them basically use the same language that the current regulation is using.
Here
The
comes the
agency
wisest
letter in
Latina.
78 said it evaluated an item on whether it had reached a stage of manufacture such that it might be readily converted to functional condition, correct? That's what you're talking about?
Exactly right. And I think that that refutes respondent's suggestion here that ATF had somehow been applying a different standard over the 50-year history of the Gun Control Act. Instead, ATF has always looked at whether the item has reached a critical stage of manufacture by reference to what work remains to be done to make it functional. So it's not like these are entirely separate and distinct contexts. As the 1978 classification letter you referenced makes clear, the only way to measure whether something has reached a critical stage of manufacture is to look at how close it is to the final product and what steps you need to take to turn that into a functional frame or receiver.
General, I want to know what our standard of review here is, because I can imagine a frame or receiver that is just a block of metal, that's not readily convertible. I can also imagine
Exactly.
some part kits that require such tremendous amount of work.
Siobhan, you're asking a great question. Why can't we see them talk? Because they don't allow cameras in the courtroom. Inside the Supreme Court, you do not have access to cameras are not allowed. So, yeah, that's it. Sorry. Supreme Court never allowed cameras. The most you'll ever get is those courtroom sketches. They will do those in these situations, but you are not allowed to show, and you're not allowed to video record. So, and that's federal courts in general, yes. So, more in Mementos is, could you record audio? No, and I wouldn't want to do that. This is official. This is the official audio that got released. This isn't C-SPAN's audio feed. This is everybody else listened to it, got the same thing. So here we go.
That it doesn't qualify as readily convertible. So if I can point to one item that wouldn't qualify, could be swept up potentially by the new regulation, is that enough to defeat a facial challenge? Is it enough? Or is that always an as-applied challenge?
That is definitely not enough to defeat a facial challenge. So there is no particular product before the court in this case. Respondents have chosen to sue in this facial pre-enforcement posture. And what that means is that the only question the court should be asking in this case is whether there is anything on the face of the rule that is contradicted by the statutory text. In other words, whether the standards that ATF set forth in the rule are themselves contradicted by the statute and therefore therefore foreclosed by the statute. And they can't make that showing here. It's certainly true that they try to suggest, and your question touches on the idea that there might be particular marginal products out there that could test the bounds of whether something is readily convertible. But the court doesn't need to consider those kinds of products in this case, because that can all be adjudicated on an as-applied basis going forward.
You use the RENA, you use the our statement in INS versus NCIR, which basically tracks what you're just saying. But in Reno versus Flores, we use a different standard and said that a respondent to prevail must establish that no set of circumstances exists under which the regulation would be valid. You didn't go that route.
That would be an even more stringent standard, and I think
agree.
a burden that respondents can't surmount. But we think even under the INS standard that we cite in our brief, it's very clear that there's nothing on the face of the Gun Control Act that
How about
prohibits
the
this approach
Washington
to
State
regulation.
range standard, which says even if there might be some applications that are intermissible, those possible applications cannot render the rule facially invalid so long as the rule has a, quote, plainly legitimate sweep.
Yes, and I think that that standard is equally satisfied as well here. You pointed to the hypothetical possibility of marginal cases where a product would take a lot of time to put together. But I want to emphasize the core of the conduct that this act regulates, which were the ghost gun kits and partially complete frames or receivers that were flooding the market leading up to promulgation of this rule. Those are issues or products where the readily convertible determination was not hard at all, because the products were specifically designed and marketed to individuals who could put them together with no specialized skill, and often in under an hour with common hand tools. And so I acknowledge the point that maybe there could be other hypothetical applications of the rule that could test the bounds with respect to certain factors. But I think that under any conceivable standard for adjudicating this facial challenge, respondents haven't come anywhere close to satisfying their burden to show that the statute squarely forecloses the standards in the rule.
What is the meaning of the term weapon in 921A3A? Can you give me a definition?
Sure. So that's an undefined term, and we think it therefore carries its.
I will say, chat, get ready. Machine Gun Sammy kind of unlimbers. He gets it. There's a lot of Alito in this case. So if you like Alito, here you go.
Plain dictionary definition as an instrument of offensive or defensive combat. But nothing in Congress's use of the term weapon suggests that it has to presently be functional as an instrument of combat in order to qualify. And in fact, I would say the rest of the statutory provision makes clear that
offensive or defensive and not a weapon of combat. You just the DOJ has just therefore increased this acknowledgement of what constitutes bearing arms. What constitutes arms? Isn't that very interesting how they do that? Isn't that interesting how they do that? They're kind of just arguing that there's an increased definition of what arms are: offensive, defensive, and non-military. So, guys, like I said, the ATF makes points here, but listen to the things they're conceding on or they're tacitly agreeing to.
that the weapon might well have to undergo a conversion in order to operate as a gun. There's an express
It may have to undergo a conversion, but before it's converted, it must be a weapon.
That's right. We certainly don't dispute that it has to be an instrument of combat designed and intended to be used in this way. And Congress made clear in the statutory history that the reason it used that term is because there are objects out there, toys and tools that have a well-known non-weapon use, but that actually do expel projectiles through the action of an explosive. A cap gun is an example of this. It expels birdshot, and so therefore it would fit within the functional definition, but it's not a weapon because it's not an instrument of combat or intended to be used that way.
Is it the case that components that can easily be converted into something constitute that thing before they are converted as a matter of ordinary usage?
I think that as a matter of ordinary usage, we're not suggesting that any statutory reference to one thing includes separate and distinct things that can be readily converted. So shifting to our arguments under frame or receiver, subparagraph
No,
B.
I want to stick with the definition of weapon for just a second.
Oh, sure.
I'm going to show you. Here's a blank pad, and here's a pen. All right. Is this a grocery list?
I don't think that that's a grocery list, but the reason for that is
Very good
there are
argument.
a lot of things you could use those products for to create something other than a grocery list.
All right,
And so it's not like
if
they're.
I show you, I put out on a counter some eggs, some chopped up ham, some chopped up pepper and onions. Is that a Western omelet?
No, because again, those items have well-known other uses to become something other than an omelet. The key difference here is that these weapon parts kits are designed and intended to be used as instruments of combat, and they have no other
We'll talk
conceivable
about that,
use.
Young.
And I think the further evidence comes from the fact that respondents themselves agreed that a disassembled gun qualifies as a weapon. So this is on page 37.
Okay, so
of the
that's
VanDerStok
helpful. So
brief.
your definition is a group of components that can readily be converted into something and have no other use. They must have no other use in order to constitute that thing.
In the
In that
circumstance,
situation, they already constitute that thing.
I think that you can recognize that something is a weapon even if it's non-functional, if it is clear from objective evidence.
No, I think that
of-
certainly is true from the face of the statute, because it's sufficient if it's capable of being converted into something that can expel a projectile. All right, thank you.
General Prelogger, I just want to follow up on Justice Alito's question about the omelet. Would your answer change if you ordered it from HelloFresh and you got a kit and it was like turkey chili, but all of the ingredients are in the kit?
Yes, and I think that that presses on the more apt analogy here, which is that we are not suggesting that scattered components that might have some entirely separate and distinct function could be aggregated and called a weapon in the absence of this kind of evidence that that is their intended purpose and function. But if you bought, from Trader Joe's some omelet making kit that had all of the ingredients to make the omelet and maybe included whatever you would need to start the fire in order to cook the omelet and had all of that objective indication that that's what's being marketed and sold, we would recognize that for what it is. And it doesn't stretch plain English to say, I bought omelets at the store if you bought all of the ingredients that were intended and designed to make them, especially under statutory language that refers to something like breakfast foods or things that can be readily converted to make breakfast.
Can
Go ahead.
Can I ask you about the difference between the destructive device and machine gun definitions that also reference parts in a way that this definition does not? I've just been thinking about in 1968 in the Gun Control Act, why Congress might have done that differently. And these ghost guns weren't around. These kits are a more recent problem, which doesn't mean that the plain language doesn't cover the unintended consequence. But
Guys, Barrett is like, well, isn't it really different? She basically helps them out there. Like, yeah, Barrett is not, I think this might be a 5-4 and she'll be in one of the 4. Because God, this is just rough from her. I'm not thrilled with Barrett on this thing, guys. We'll keep going here, but I'm just saying. Oh, somebody booped in. Kurt from Uncivil Law. Hey, man, how you doing?
So I heard you were trying to discuss the Constitution.
Just a little bit.
Hmm.
The only amendment that matters.
Can you quote it from memory?
What the amendment?
Yeah, I can.
Hold on. What do you want, babe? Yeah, I know that's a thing, though. I mean, I shouldn't. Neither you should be here. It should be Robert Barnes. So,
Yes. Yeah, well, he is the foremost expert on the Constitution, surely.
Yeah.
So, yeah.
Yeah, no, I mean, it's... but no, did you want me to say it? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, I think.
You got it, baby.
I got it? Okay, close. I get that first part. I'm like, shall not be infringed. It's like, it's all that matters.
Yes, but more to the point, of course, for today's purposes, the statutory confines that is the Gun Control Act of 1968.
Yes.
And what it does or does not teach with respect to what is or is not a gun, with notable attention to what is not the frame of a gun.
Yes. And are you familiar with like the 80% frames, Kurt?
I am very familiar with this issue, yes.
And it's interesting because everybody's like, oh, well, the ATF got their PP slapped with the bump stocks. And I'm like, yeah, but that was a bit different, guys. This is, when you're going to talk about criminals running around with guns, every judge gets a little antsy in their pantsy about it. Even the most, even Barrett's clearly starting to get a little concerned with it. because it's not only here where this has an implication, it has a lot of implications for other federal agencies. So
How
just
so?
keep that in mind, guys. Well, I think it would go to like the ATF's interpretation being out of line with the Gun Control Act. I could see this just being parlayed by other groups that this is, well, it's just like what the ATF did here. And I think they want to.
Well, we're going to do that anyway, regardless, because since the death of Chevron from Looper Bright,
yes,
that's, I mean, regardless, it's all like, well, this agency is, blown up the statutory text. So, I mean,
yeah,
even if the ATF wins a day, it's not going to prevent anyone who's from saying, well,
no,
this agency's totally screwed the pooch on this other statute.
It won't, but I just think, I still have the theory the government's a branch, the courts are a branch of government, and the tree rarely attacks itself.
They are, in fact.
So,
yes.
They.
I don't know. That's fair. I mean, the courts and the Supreme Court rule against the other branches with fair notability.
Yeah, they do, but it's never. I don't know. I just like it's kind of like the whole idea of like people are like, well, will we ever get machine guns? And I said no. You would need 9 Clarence Thomases on the Supreme Court to get machine guns legalized.
That's probably true. Yeah, if you want to try to undo the underlying Gun Control Act or National Firearms Act or something like that, yeah, you're going to need. You're nowhere there. And this also is just a generalized critique I have when it comes to Second Amendment advocacy, because I'm a strong supporter of the Second Amendment. I've been a legal advisor for gun rights groups, and the problem is, for better or worse, excuse me, for better or worse, the Second Amendment just doesn't get enough love, generally speaking, and there's just not enough baseline law. So a lot of the Second Amendment people want to sort of jump to the end of the page, and I'm like, I totally understand that you want as much Second Amendment rights as you believe the Constitution should give you, and I get that, but you got to do this in a more smart way, because you can't it's like trying to build a building. You got to build the foundation first, and unfortunately the case law just kind of isn't there for a lot of it right now.
Yes, well, and I've likened this very much to like the civil rights movement. Yes, Brown versus Board of Education was great. It wasn't the end though, and it took
Brown also came like 70 years after like Leslie.
Well, I'm just saying though, it took
a long time to get there in the first place.
Well, yes, but I'm just saying, once Brown versus Board of Education happened, go through, it took another, through the 60s, the 70s, the 80s of, people having to go to court and the Supreme Court smacking down laws that were, like, I'm just saying, it takes a while, and kind of mirroring what you said, it's going to take a long time. It's a long march, but you have to keep pushing.
I think the Second Amendment people would be more well advised to look for what low fruit they can get and kind of work their way through this in steps. It also would help, incidentally, if the Supreme Court just took more Second Amendment cases, because every year for the last, I don't even know how long, let's say 70 years or 80 years, they've taken 3 to 5 First Amendment cases every year for 80 years. So it would be nice if they took as many Second Amendment cases, because it needs love.
I agree. But I'm just thinking, like, I remember in one of my for one of my con law classes, I think it was, where it was like a hot dog stand was being racist, and like, it's like into the 70s, like, oh, well, you privately can't do it like that. And it's just like, you have to attack and chip away everywhere you can, and then eventually you get to the end, and there's death of 1,000.
Because the Heart Atlanta Motel, and what was the barbecue case one?
Yeah, I don't remember that. I forget the name of it, but yeah, it was. But
Ollie's, I think it was. Wasn't it Ollie's Barbecue?
Yeah, something like that. Yeah.
Those would be your foundational. Those would be your foundational. Private businesses can discriminate. No, they can't cases.
Yes. Yeah. So, guys, that's all I'm trying to say is it's a long time. It's a long time. So, regardless of what you think is going to happen today, don't get down.
Okay, let's see what we got.
Yeah, here we go.
In 1968, and I don't know enough about the gun industry to know if this is right, which is why I want your take on this. Wasn't it the case then, I think, that destructive devices like grenades or even machine guns were not things that you tended to buy whole, because they were so heavily regulated and even illegal to purchase that way, as opposed to firearms? So they were generally purchased as components or things that were able to be converted or made. Like, it would make sense to think about it in terms of parts. Am I thinking about that correctly based on the industry at the time?
Yes, you're exactly right about that relevant difference in how people were ordinarily constructing things like destructive devices that weren't sold in these types of kits. And I think the important thing to recognize, and what this question presses on, is that Congress can use a variety of verbal
I love
formulations
Preligar,
to
though.
cover similar types.
You do?
I love
You do?
Elizabeth Preligar. I think she's so brilliant. I mean, I will disagree with her on legal interpretation, but I think she's one of the greatest Supreme Court advocates of recent memory. I'm not sure this haircut's necessarily doing her any favors, but she's brilliant.
Yeah, and apparently she clerked for Garland, I think, is something people are saying.
Yeah, she's absolutely brilliant. I love Preligar so much.
Yeah, so here's something, and if you haven't ever seen one of these before, Kurt, have you ever seen these flyers before of, this is like 1960s. You're like, oh, machine guns weren't easy to get. Like, no, they were literally like $50. Or you could buy.
Those are good prices. You think they'll still be honored?
I don't think this company's around anymore.
Damn it.
But, yeah, you could buy a Schmeiser. You could buy an MP40, $49.95. Extra magazines, $7.50 a piece. So this, I just love how they're talking about.
That's funny though. To me, those prices are just. If the gun itself is $50, but the magazine's $8. I mean, that seems.
Well, they knew where to put the markup.
I guess. Damn.
That's why Pop's your moneymaker at a store. But no, I think it's funny. They talk about this, and I'm like, I could have mailed out, and they would mail me one, and I would get the tax stamp for it. Like, there were no rules. Even after 1968, there weren't really rules. When you see a gun flyer.
There wasn't a tax stamp yet.
There was tax stamp from 1934. Yeah. So what would happen a lot? So the thing the ATF would do a lot of times is, and there is a case where the ATF got PP slapped really hard because of the Fifth Amendment issue. You would submit a stamp application to the ATF, and the ATF would then look at it and say, Kurt lives in Virginia. Virginia says machine guns, are a crime. And they would call the Virginia State Police, say, hey guys, this dude named Kurt's got a machine gun. And then they come arrest you for violating state law. Well, the Supreme Court's like, you can't do that. That's a Fifth Amendment issue. You can't get people to comply with the law and then turn them in like that. It's US v. Haynes, I think, is what happened there. Hayne. So, yeah. But no, if you ever want to see something that's really sad, look at like machine gun. Like, you can see these flyers in the late 80s, even into the early 90s. It was still like these guns were dirt cheap. Now these guns are like $10,000 minimum. So,
yeah, because after the 86, they stopped allowing new ones to be sold.
Built, yes, but there were a lot of them out there. So even into the 90s, it was still pretty cheap. But yeah, the thing is, this is like 1963 though, so $60 was a lot of money. So
I'll pay the inflation adjusted price.
Yeah, so will I. So would I. But we'll get back to your crush here. She does a very good job, and I mean it's guys, just so you understand,
really really good.
She is not the attorney for the DO. Like, she's not the ATF's attorney. She's literally just there because she has a very good knowledge base of constitutional law and it can argue very well. I'm sure because she's also a company man. She's like, oh sure, I agree with whatever the government's doing for the most part.
She was also like Miss Idaho or Miss Idaho pageant. Yeah.
Oh.
So she's brains and beauty.
All right, so here we go.
Of conduct. Each of these other definitions that respondents have pointed to that refer explicitly to parts were enacted at different times from the relevant definition of a firearm, and they address different issues in the way that your question touched on. But what respondents are doing is ignoring the language of the statute that Congress did use in 1968, and it expressly referred to things that can be readily converted to function to expel a projectile through the action of an explosive. It's hard for me to see how a weapon parts kit doesn't fit within that plain language, because quite literally, the kit is intended and designed to produce that functioning weapon in a very short amount of time by people who don't know anything about guns and can do it with relatively little skill.
General, I understand your argument under A with respect to things that could be readily converted, but there's also the argument under B, frame or receiver, which doesn't include that kind of language that might bring in artifact nouns more obviously. What's your thought about that?
So I do think there's language in B that gets us there, and it's the fact that Congress referred to frame or receiver, but didn't expressly define that term. It's true that in subparagraph A, Congress used the exact language readily converted, but that's because that's Congress's definition of the term, and if it had defined it solely in terms of the functionality of a gun, if it had just said something that functions as a gun, that would be limited to operational weapons. So Congress had a really good reason to use the language there.
Gotcha. I follow all
Yep.
that.
So then
Now moving on to B.
So
though.
moving on to B, Congress didn't define the term, which means it carries its plain and ordinary meaning. And we think that the ordinary meaning of a noun like frame or receiver includes objects that are nearly complete but are missing just a few holes that need to be drilled.
Now, we can't possibly think that every noun that Congress uses everywhere in the U.S. Code is used as an artifact noun that carries with it things like Justice Alito's pen and pencil as a grocery list, right? So there's got to be a line that makes this, on your theory of the case, why we should read that into B here, but not everywhere in the U.S. Code. What are your thoughts?
Right. So I want to be very clear that we think that this is a matter of ordinary meaning, that you don't need it to be 100% complete. And that I think that runs across the board. If I mentioned a bicycle, but it was missing pedals, as we explain in our brief, you would still recognize that for what it is as a bicycle.
Good answer.
That's the first order question. But then the second question arises that you touched on.
If I'm not inclined to think that every noun is used in that way in the U.S. Code, I mean, that would be a very dramatic argument, right? The lenity, notice, fair notice to people that every piece of paper and pen is a grocery list. You're on notice of that. But is there something particular to this statute that you think would a more narrow approach?
Yes, we think the context and purpose of the statute strongly support understanding the term in this way. And the reason for that is because throughout the federal firearms laws, whenever Congress has itself expressly provided a definition, it has included not only the fully complete and functional item, but things that are the item and can readily be made to function that way. So I think that's Congress's own indication in this statute that it's trying to ensure coverage not only of things that have the functionality of a frame or receiver at the moment they're sold, but frames or receivers that can be readily converted to function with minimal steps.
If you have something textual, I'd love for you to point me to that and also address your friends on the other side. I'm sure going to make something of this, that as recently as 2021 in a brief filed in the Southern District of New York, the government represented that an unfinished frame or receiver does not meet the statutory definition of firearm.
Sure. So let me take those in turn. With respect to text, what we have, Justice Gorsuch, is the term frame or receiver that's not defined. And the court has many times recognized it needs to interpret text in context. I think the anti-circumvention principle carries a lot of weight here, because if respondents are right and just one undrilled hole is enough, then basically that coverage for frame and receiver does no work.
Does it help that C and D deal with mufflers, silencers, and any other destructive devices that don't have conventional frames and receivers? Does that help you?
I think that that just goes to show that Congress was trying to broadly cover the scope of products that can qualify as firearms, and it certainly refutes respondents' suggestion here that every covered object under the statutory definition needs to have a traditional frame or
That's what I'm
receiver.
wondering, whether looking at C and D and A, which, as you say, carries some broad language about not just complete items, might be a textual way to narrow and focus on B without saying every artifact noun in the U.S. Code carries this feature.
Yes, I think you certainly could adopt that interpretation, and that contextual surrounding evidence strongly supports our arguments in this case. I don't want to lose track of your question about the brief district court filing in the Syracuse case. I want to be really clear that I think respondents are fundamentally misreading that brief. They suggest that the brief stood for the principle that ATF was arguing that a frame or receiver has to be fully functional to qualify. But if you actually look at that brief, that's not what it says. It walks through the statutory and regulatory history here and makes clear that repeatedly over 5 decades, ATF has always looked at whether a partially complete frame or receiver can be brought to functional.
That's what the law is, pretty much. It's arguing semantics.
Yeah, no. Did someone say that about semantics? Yeah, no, that's exactly what law is. Welcome to law. That's semantics. Yeah. That's what we do.
Yeah, that's all we're doing here. And I'm not trying to make fun of you, Coke Fairy. You are 100% correct. Yes. Yes, and it's this is very much what that is. So
condition quickly, easily, and efficiently. So there is no dramatic break in the way that ATF has regulated throughout the entirety of the statute's history.
Well, I'll look at that again. And then last question from me, and I'm sorry to take up so much time. In the regulation, it indicates that a frame or receiver, and I'm stuck on this B point, which has been cut into pieces, is still a firearm.
So this
But one that's been shredded is not. Now, I'm not sure what the difference between cut into pieces and shredding is, but perhaps you can enlighten me and help me there.
So this refers to when you already have a fully complete and functional firearm, what steps you would need to undertake to formally destroy that firearm and exempt it from location. Those are not
it's
provisions.
no longer readily convertible. Right. And
So once you actually have already brought something within the regulatory scope of the statute, the statute itself and the agency's regulations require that it be destroyed, which is a specialized term in the firearms industry. I can tell you as a factual matter that the most common way that you destroy a firearm is to torch cut it with 3 specified cuts that ATF has provided guidance about.
This is
That's
I'm
correct.
sorry to interrupt, but this is actually about frames and receivers that I'm talking about, and it's 478.
That's the demilling process, guys.
C and E.
Yes.
Okay. And it talks about partially complete, disassembled, or non-functional frame or receiver. That's what we're talking about, not the firearm. And again, maybe there's a line a through line, but I couldn't find one between shredding and cutting into pieces. I would have thought that's pretty much the same thing.
So that comes, as you mentioned, from 478.12E, which I should note respondents haven't challenged in this case. It tees up a distinct statutory issue about what it takes to destroy a frame or receiver or a regulated object once you already have a firearm. They aren't challenging that here. And the only thing that is before the court is the definition in B, recognizing that you don't need a fully functional firearm in the first place.
No, but it illuminates what is a sufficiently complete frame or receiver if a complete frame or receiver is not a firearm. And the only way I can be sure that I don't have a fully complete or nearly complete or convertibly complete frame or receiver, and therefore a firearm, is to shred it but not cut it.
Oh, no, let me try to clarify.
And Chad, before we get too far, I know showing guns, YouTube will scream at me for this. But if you guys want to see what they're talking about when they say 478, they're talking about 27 CFR 478.12. And this is where the ATF, through its, remember guys, they don't just use laws, they use the regulations. They break down what are considered frames for revolvers, pistols, semi-automatic pistols, bolt action weapons, lever guns, the AK-47 platform, the Steyr AUG, the MP, HK platform weapons, a Tommy gun, an FN FAL, a Sterling, which it's funny because that's literally just a metal tube with holes cut in it. And then they talk about, like, for an AR-15, the typical lower receiver, all the common guns that are out there, and you see them when they talk about these things. So you see they're talking about destroyed frame or receiver. This is what they're doing here. And if you want that again, that's the citation, 27 CFR 478. Just so you understand what they're talking about. Just to make that clear.
Do they talk about zip guns at all in this case?
They kind of talk about pen guns and umbrella guns for a second, but that gets going after a little while.
Well, like you can make depending on what, you can make something that fires a projectile using things that you can find at a Home Depot.
Yeah, you can 3/4 inch pipe. It's 12 gauge.
Yeah,
Yeah, 3/4 inch pipe and just you can make a bang stick.
So I guess, is Home Depot a gun? Or
Yeah.
if I give you a list of things to buy at the Home Depot, is it now a gun?
Yeah.
If you buy those pieces, is it now a gun? There's all kinds of interesting questions
there's on my workbench, there's 1 inch pipe, 3/4 inch pipe, a pipe cap, and some nails.
Which may or may not be a gun.
Well, not yet. Not yet. Oh. So, and yes, there's a great book that covers this, written by P.A. Ludi. Yes, a guy in Britain went to their version of Home Depot and built an Uzi, basically.
Excellent.
Yes, he went to prison over it, though, because they they consider that terrorism. And he got cancer while he's in prison, and they didn't treat him, and he died, sadly.
Well, it's not good.
Yeah. And the neat part is you can download it. HomeGunsmith.com.
You wouldn't download a gun, would you?
I've already done that a couple of times. So.
Well, yeah, and then it's like the sort of one of the earlier questions is like, okay, so 100% receiver is just what you'd buy at a gun store. A 0% receiver is just a block of metal.
Yeah.
So exactly where in this is it readily convertible? And
well, that becomes the issue.
Does it depend on technology? If I give you a 3D milling machine, is it now is a 3D milling machine plus a 0% receiver now a gun?
Yeah. Well, the other thing is though, you get to like they talk about skill set, and I think that's actually I think that's a horrible argument because, because I'm not very skilled in machining, but I understand it and I know how to do it. Does that make me well skilled? I mean, there's a bunch of this stuff is not clear. A bunch of this stuff.
Also, that I don't really particularly like that answer because it implies that what a gun is or not depends on the skill of the person in their machining ability.
Yeah, or just their knowledge.
Which seems like a very odd conclusion.
It is, and you have to prove, how do I know this stuff? And I could easily go into court and be like, well, I don't know that anymore. I guess I forgot. It's going to be like, we'll have to prove you're a witch. They'll throw you in front of a lathe in the courtroom. Be like,
does that imply if skill with machining implies your ability to make it a gun or not? Does that imply that a person could be so untalented that even a thing they buy at a gun store is not a gun because they lack such ability that to them they lack the ability to readily use it?
Oh yeah, I think
a possibility.
Yes, I think that means then you could theoretically have a law. You're too incompetent to break the law.
Yeah, basically.
And I agree. No, I agree. When they make that argument about skill, I'm like, you're saying that people are too incompetent to break the law, and that's not right. Yes, the machinist is the gun. So let's let him keep going.
Well, wasn't it Michelangelo who said that the statue was always there? He just got rid of the unneeded bits. So the gun was already there in the same sense the statue was.
I think he said that, or it may have been Raphael, but yeah, I've heard that before. Yes.
Yeah.
All right, let's keep going here.
As the regulation itself makes clear, you don't even get to the question of asking whether it's readily converted into functional shape unless you have the clearly identifiable unfinished component part. So you have something that is already well along the way to being a frame or receiver, and that's when you would conduct the readily converted inquiry. And there is nothing in the rule or in the agency's past practice to suggest that anything that isn't shredded or cut up or absolutely destroyed is going to be considered a frame or receiver. That would be entirely inconsistent with how the agency has implemented the statute all along.
Thank you.
Under the rule,
what
percentage of the parts of the firearm kit must be included in order for it to be a firearm kit?
So these kits always come with a frame or receiver, and I think that that's going to be a necessary part. That's usually the part that needs just a couple of holes drilled or pieces of plastic removed. And then the weapon parts kits generally come with the additional components that will allow you to form a fully functioning gun. If you're asking whether it would still qualify as a regulated weapon that can be readily converted if it were missing other parts, I think that's a matter of degree, and it presses on what it means to readily convert. It might be fact specific. So if the part you're missing is something that is super specialized and would be hard to track down or is going to cost you $1 million, that might not be readily converted. But if you have something that's missing a single pin that you might even have lying around the house, it probably will be. Again, in this facial challenge, I don't think it's necessary for the court to consider all of the possible permutations of how this could play out with respect to different types of products. The thing that you need to be asking is, did the agency reasonably define the term readily? And it did, because it gave it its ordinary definition of a process that's quick, easy, and efficient. And then did the agency identify relevant factors? And I think it did with respect to things like time, expertise, scope of work, and as your question touched on, what parts you would need to actually make it functional.
General, we have a clue from the statute's use of a starter gun as an example of something that's readily convertible. as I understand it, to make a starter gun operable, you either have to replace the bore, so you need a new bore part to do that, or you have to drill out the existing bore on the starter gun and get a pin to make it operable, correct?
Reboring
That's
out a
right. So
revolver
the
would be a lot of
most,
work.
commonly publicized example that I think was top of mind for Congress, and it's one that's cited in the statutory history here, was the example of a gang member who bought these starter guns in bulk, and then you're exactly right, had to drill out the plugged barrel or else cut it off and rethread it and put in a new barrel. And often you also have to enlarge the barrel so that it can chamber conventional ammunition if it isn't already
I just have one
able
more
to
thought.
accept bullets.
Can I
So
pause
we
for a
know
second?
that some incomplete items
I just have one more.
qualify.
Yes, go
I
for
just
it.
have one more thought because I don't know if this is still true, but I believe this used to
Mhm.
be true because whether or not you can import certain guns depends on whether or not they can be used for what's deemed as a sporting purpose.
That's still a thing. yeah.
And I know it was the case at one point that
The Gun
certain
Control
kinds of
Act created that.
guns, and I want to say like a revolver, like the ATF determined that if the barrel was too short, it didn't have a sporting purpose. So they
Correct.
would manufacture it with a
Mhm.
barrel for the sole purpose of when it came into the United States. Then they would just shear it off.
Mhm.
But it was imported. It was imported with a barrel that was the right
Yes.
length, and they just shear it off, and then they would sell the thing. And
Mhm.
so, and then they would just send the barrel part back to Brazil or wherever to
Mhm.
reattach it again. And so, it also raises the question of, well, if that's now readily convertible, from the non-sporting purpose, then maybe the workaround doesn't work. It's like what workarounds do work and what workarounds don't work is also sort of a more nebulous concept here.
Yeah, well, that's normal though. I mean, like the idea of thumb hole stocks, where you could put your thumb goes through the hole of the stock on rifles. They were importing AKs like that. They take a piece of plywood, cut a hole in it, and bolt it onto the back of it. Say, see, it's a thumb hole stock, and then you'd import it and you'd switch them out. Be like, see, it's got imported legally. That import laws with firearms is all a game of, well, you didn't say we couldn't do it that way. And then the ATF goes, fuck. And then they go back and come up with a new rule. And then the gun importers think of a new way around it. So.
Which makes you think that maybe this entire regulation is pointless too, because you're just going to run into the same problem with what is or is not a frame. It's like 80% is too much. It's like, okay, we'll sell 75% frame.
Yeah, well, that's what I mean.
It's like, we can't sell it. We can't sell it with the jig. Fine, the jig is now sold separately. I mean,
yes.
whatever.
Well, that's the thing. Well, they're trying to. I mean, eventually, what they're going to argue is that even if you're just selling the frames, that's still a firearm. I mean, so while the ATF is making the argument, if you sell this shit together, it's a firearm. Eventually, just selling these readily made frames by itself, their goal is they want all that to become a firearm as well. So, I mean, that's where they want to go with it.
You think the ATF just wants the ability to control all the things?
Yes. Yes. 100%. I'm not sure if you were asking in jest or seriousness, but yes, I think they do.
The statute's definition.
Yes, and I think that also shows, as the statutory text makes clear, that things that aren't presently functioning as guns but can be readily converted to function are covered under subparagraph A. That was exactly what Congress was trying to accomplish, to ensure that these things that are going to be used as instruments of combat and that can be completed to functional condition with minimal work would come within the scope of the federal firearms laws.
Thank you, Counsel. Justice Thomas and Justice Alito.
Here's Uncle Clarence.
Were weapons parts kits common in 1968?
So there have only been a couple of examples over the years that I'm aware of reflected in the case law. We cite the Stewart case and the Witt case. One of those was kind of an Uzi making kit. Another one involved someone who was making it possible through kit form to construct a machine gun. It wasn't particularly common then, and I can tell you the reason why. The big development and the technological development that led to the explosion of ghost guns was using polymer, a form of plastic, to make this.
Are there gun kits available now that do not consist of polymer parts, but instead consist of parts taken from disassembled firearms that have been altered in a way to make them non-functional without some modification?
I'm not aware of any commercial product right now that fits that description.
And that's because you're an idiot. They sell multiple guns like that. You could buy multiple guns for many, heck, like a G3 assault rifle. I'm planning on building one soon. You can buy the parts. You can buy the receiver. And they're all disassembled. Right now, they're cheap as hell. Guys, if you're looking for a gun to build, the Portuguese G3 kits came in. So, like, everything's dirt cheap right now. Just so we're on the same level.
Can I come over to your place and we can do a build together?
Sure, we'll do it. Well, you're gonna learn with me, but yeah, we'll make a G3. We'll make 308s.
Excellent.
Yeah, Torgo, we are gonna hear from the plaintiff in a sec, we're gonna hear from VanDerStok in a second. But yes, you could do it with AKs. They make AK kits where you sit there and you put it in the press and you bend it, you weld it in, and then you pop the rivets in, and then boom.
Would you like to build a snowman?
Yes. Oh yeah, and I'm not joking. They were back in the early 2000s when you could do an AK for like $100. They were literally guys would go to Harbor Freight, buy a press, and you would have what's called a build party, and like 8 or 9 guys hang out, drink some beer, and you put together like 8 or 9 AKs in the course of a day.
Sounds like good old American fun to me.
Yeah.
We'll invite Ian down.
Yes, and somebody say yes. Fudbusters wind chime kits. Yes, and as stated, I forgot to mention one of our sponsors for the show, MAF-arms.com.
You've got sponsors?
What's that?
You've got sponsors?
Well, the promo code, and then I get a cut of the action. So it's kind of sponsors. But friend of the show, Matt from Fudbusters, use the promo code POTGRIM and you get 10% off all of your wind chime and wind chime products that you may be looking for. Promo code POTCRIM. They have wind chime kits for everything, chat, including all kinds of Romanian wind chime kits, hitchhiker wind chime kits, Tack Daddy wind chime kits. You know, check him out. He's got a great selection over there at maf-arms.com.
I like wind chimes.
Yes, well, yes, they're wind chimes. If you go to maf-arms.com, you can see how the wind chimes are set up. Yes. I Take It Good says, so lower your voice. When's the next kit stream? Well, I gotta figure out when I'm gonna do it. But yeah, I would like to do this as a winter project. Build the G3. It'll be fun. And then yes, there's an FGC9. Yep, you can build an FGC. They have FGC9 kits as well. That's the one. That's the big one to print. So, yeah. Well, Sleazy, I can't put that on screen, so they'll get mad if I do that. But Sleazy does have the correct address there. Yes, the most beautiful wind chimes. So I love when they talk about that. Like, no, you can't do this. I'm like, yes, you can, and it's all metal. So,
excellent.
Yeah. Anyways, it's just you love it when they're wrong. You love it when they're wrong.
On what it means to be readily convertible, I don't know whether it's possible to do something. That's the statutory term.
I know I have
don't
like
whether
60
it's
of them.
possible to do something more precise than what ATF has done, but it would be interesting if it would be helpful if you could perhaps explain a little bit more what that means. So what level of expertise is taken into account? What collection of tools is taken into account? Can you provide any sort of a time limit? How long must it take? Some of us who are not and don't have a lot of mechanical ability have spent hours and hours and hours trying to assemble things that we've purchased.
I'm with you on that one, Justice Alito, as someone who struggles with IKEA furniture. Let me do my best to try to be responsive to that question. And I think the thing to point to is the case law on this point, because ATF wasn't just coming up with these factors out of nowhere. Instead, because this is the term that Congress used in the statute, we have 50 years of judicial precedent further fleshing out the contours of when something can be readily converted. So as a general matter, what the courts and therefore what the agency has said is that it is readily converted if someone if a novice in a fairly quick amount of time can easily and efficiently convert their weapon to function. You asked about outside bounds like time limits. I can tell you that in the case law, the longest period of time that was ever deemed still readily convertible was 8 hours, and the agency has not considered any product greater than 8 hours to be readily convertible. So if that issue were squarely presented, a court might hold that something like a day's work or 8 hours sets an outer bound. With respect to things like skill or parts availability, obviously that's going to be fact and context specific. And I think the important thing to recognize is that these are principles that were themselves drawn from case law. And the agency, I think, can't be expected to do better than courts themselves have done in trying to flesh out the qualitative standard that Congress chose to use here.
Thank you.
Justice Sotomayor? Justice Kagan?
On parts kits first, in addition to the parts kit that's analogous to an IKEA table kit, Judge O'Connor below was...
Guys, and I just want to say we do have Kevin James here in cameo playing the role of Justice Elena Kagan. So buckle up.
That's mean.
Concerned that
Well, I mean, it is what it is.
that language would include sort of any aggregation of gun parts. So let's say, a gunsmith just wanted to replenish inventory and got a big box of gun parts generally from a gun manufacturer. Would
It's
that
how they like to
count
talk about these like
under
they're widgets.
the ATF?
It's so esoteric to talk about
No,
guns.
the lower court fundamentally misunderstood how this final rule operates. In the first place, it doesn't regulate something like.
And
a
if you
gunsmith at
replace
home
every
who's
piece of
buying
the gun with
individual
different
parts and
pieces,
seeking to
is it still the
aggregate
same
them.
gun?
This is a regulation that only
Oh,
governs commercial manufacturers
Now we're getting
and
into law
sellers
school
of
arguments.
firearms who are
Is it still
themselves
the same
constructing
car?
the weapons and the kits and putting them on the market. So these are just conditions on commercial sale. And then with respect to what the rule would cover, it's clear from the readily convertible analysis that you need to have a process that's fairly quick, easy, and efficient. And so it wouldn't sweep in things that have a lot of other uses and that would require a lot of skill and expertise or time to track down the missing parts to put together. And I want to emphasize again, it's not like ATF was coming up with this rule without real world experience about the kinds of products that these fringe manufacturers were putting on the market. These were kits that you could put together in under an hour. They had all of the relevant components. You would just need to do a little bit of finishing work. I actually had the experience of putting one of these kits together, and it's just like what the record shows. There are usual.
Oh, hold on. I forgot. She said, I forget. What kit did she say she put together? Hold on here. What kit did she say she put together? Hold on here.
In the first place, it doesn't regulate something like a gunsmith at home who's buying individual parts and seeking to aggregate them. This is a regulation that only governs commercial manufacturers and sellers of firearms who are themselves constructing the weapons and the kits and putting them on the market. So these are just conditions on commercial sale. And then with respect to what the rule would cover, it's clear from the readily convertible analysis that you need to have a process that's fairly quick, easy, and efficient. And so it wouldn't sweep in things that have a lot of other uses and that would require a lot of skill and expertise or time to track down the missing parts to put together. And I want to emphasize again, it's not like ATF was coming up with this rule without real world experience about the kinds of products that these fringe manufacturers were putting on the market. These were kits that you could put together in under an hour. They had all of the relevant components. You would just need to do a little bit of finishing work. I actually had the experience of putting one of these kits together, and it's just like what the record shows. There are usually only a couple of steps. The first thing that most of the kits were.
I'm sure she really didn't sit there and put together a Glock.
I mean, if she actually took the time to put the kit together in prep, which doesn't sound outrageous, but if she really did it, mass respect.
Yeah,
mass respect.
I did it. Like I said, I did it for Halloween. I put together the one behind me as a bit of fun. I got my ass kicked by it because I didn't use my Dremel right. But yes, it didn't take forever, but it took a little while.
Require is drilling the holes. Usually it's 6 holes, and you do it with the jig.
And
so
drill
you
your
have the
holes.
product there in the tool, and it removes all of the trial and error or guesswork. You know exactly where to drill in seconds. The second step is to remove
Unfortunately,
the extra
she's
plastic
married.
blocking tabs. That again doesn't require much work at all because you clip them off with a pair of pliers or a box cutter. You can file it down with a jig as a template using a metal nail file or using a Dremel rotary tool that a lot of people, especially dog owners, own because it's helpful for trimming your dog's nails.
How many dog owners own a Dremel because, I'm using the Dremel on my dog? You know what happens when you fire up the Dremel and it goes like that's gonna scare the shit out of your dog. No, most people own Dremels because it's a useful tool, not to Dremel your dogs. What a total fed. She's like, I Dremel my dog. I Dremeled into his skull yesterday. Yeah. Larry's like, my dog wouldn't let me near him with a Dremel. I agree. Clyde would not let me near him with a Dremel. So.
At that point, you have a fully functional frame or receiver, and you can quickly assemble it into a gun in no time at all. That's how the products were marketed. That's how they were sold.
And turning to
Yes.
the frames or receivers, you made a point of saying that this follows
People
a
having
long
access
line
to
of
freely available
regulation.
firearms is a good thing.
But there were changes, right? That the new regulation is intended to capture items sold with jigs and templates. Is there anything else that the new regulation was intended to capture that was not captured under the old? And why did ATF make that change?
No, that is the only change. ATF made that change and openly acknowledged and justified its decision because it recognized that when you have a jig, which is this tool, as I mentioned, that removes all of the trial and error and really does make it dummy proof, as the manufacturers have claimed, it goes directly to the question the agency has asked all along, which is how quickly, easily, and efficiently can this thing be made to function? So it's no different in kind from indexing on the frame or receiver. Indexing is something that ATF has looked at from 1968 on. It's always recognized that if you actually put a dimple in the frame or the body of the structural component, that's going to speed up the process, and jigs work exactly the same way.
And let me ask you a broader question. If we step back a little bit, sometimes this court looks at regulations and it says, there's an old statute, and the old statute doesn't contemplate a new problem. And a new problem comes up, and Congress can't get its act together and deal with the old problem. And so the agency takes old statutory language that doesn't really fit the problem, but, is vague enough or general enough or broad enough, so that it can be kind of made to deal with the new problem. And this court has sometimes said, well, that's not right. The new statute had nothing to do with the old statute had nothing to do with this new problem. And this is kind of, the agency just taking over what is really Congress's business. Is that a storyline that the respondents here can tell about this regulation?
No, I don't think there is any tenable way to characterize this regulation as an attempt to change the meaning of the statute to confront a new problem. First of all, this is an age-old problem. Congress, I think, rightly recognized that manufacturers.
There's something you want to say, Kurt?
This is like, really? There's no way to characterize it as trying to deal with a new problem? Didn't you just say, well, this used to be the problem, it was dimples, and then they changed it, and then we had to change.
This is literally
if it's not an attempt to deal with a new problem, then why'd you change the regulation at all in the first place?
Yes, because you admitted this didn't exist before new technology was invented.
That doesn't make it. It doesn't make any sense. Why change the regulation if you're not trying to deal with a new problem? That doesn't make any sense.
Yes. Okay. Yeah. No. It's government lawyers.
Might seek to evade these central requirements. That's why anytime it's expressly defined a term, like in subparagraph A, it's included concepts of whether an item can be readily made to function. We think the weapon parts kits are precisely described by that subparagraph A description. I acknowledge in subparagraph B, it's not a defined term, frame or receiver, but there again, we think that Congress was simply tracking ordinary meaning, which recognizes that if you have that principal structural component of a handgun, that can be recognized as a frame or receiver, even if it's missing the single final hole that you need to drill in that. So I think it would be wrong to suggest that the statutory language just on its own terms doesn't cover this situation. And then on top of that, we have context and purpose here. On respondents' theory of the statute, it would be incredibly easy for any gun manufacturer to avoid the regulation and the essential requirements of serializing, background checks, and record keeping just by leaving one little part of the weapon or the frame or receiver unfinished. Plainly, that's not what Congress was intending. And I think it brings this case squarely within cases like Abramski, where, as you know, Justice Kagan, the court recognized that.
So, guys, Abramski was a case where the guy did a straw purchase for his dad. And he was a cop, and he bought a Glock pistol on the you're in law enforcement, Glock gives you a deal on things.
That's right.
So he bought a Glock for his dad. Now they did a straw purchase a stupid way. His dad was a dumb old boomer, and his dad wrote him a check, and then on the check memo line he wrote, "Buying my gun for me."
Yeah.
Now it didn't help. Abramski was also a crooked cop and got hammered on a lot of different things, and then he got hammered with the gun charge too. So remember, there's generally a reason why that happens like that. But yes, Abramski was that was not a good fact pattern. And yeah, the Supreme Court nuked him. But yes, it's a hilarious pattern with the boomer writing checks.
If you have an interpretation of the Gun Control Act that is going to allow that entire circumvention and essentially nullify the act's requirements, the statute shouldn't properly be interpreted that way.
That was a close case. You maybe want this to be a stronger case than Abramski.
It is a stronger case, and the circumvention here is even more profound because it wouldn't just be in the sales transactions with the straw purchaser. It would effectively be all weapons going forward would not need to be serialized or sold with background checks and record
based.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
Should you just say that we can get rid of the entire gun control system?
I
That'd
had
be
some
great.
concern at the stay stage, and I have some concern now about mens rea. And this is an agency regulation that broadens a criminal statute beyond what it had been before. So what about the seller, for example, who is truly not aware that they are violating the law and gets criminally charged? What assurances can you give about mens rea, about instructions to the jury that the government would seek and the like?
So let me begin with the statutory mens rea standard that I think fully addresses this concern. This is in 18 U.S.C. 924A1D, and it requires willfulness.
I've always thought when the government's in these positions and they have to make a statement, that should be binding on every federal action in every court in America going forward until they formally change their position in court. Like, I think that'd be a great, because, she says all this, but if that was the case, and everything she said was writing on that, I don't think she would say the same thing, personally. So,
interesting.
Yeah. Well, I mean, if they're going to make this argument, when the government's in court making arguments, I think people have a right to rely on them, especially when it's the highest court in the land and it's not just some random Yahoo in federal court somewhere else.
So that means that if a manufacturer isn't putting a serial number on it because the manufacturer believes in good faith that this isn't a regulated product and the manufacturer doesn't know that it's violating the law, it will not be criminally chargeable because the government won't be able to prove that mens rea of willfulness. So I think that's an important check against criminal prosecutions that might be unwarranted. The second thing I would point to is
Does this willfully apply to all potential prosecutions that we're talking about in this case?
it applies if there's no serial number on the weapon, and it applies if the weapon is being sold without a license. I believe that with respect to not conducting a background check, that's under a different provision that requires knowledge. But of course, the kind of entry point for the weapon is whether or not it has a serial number, and that happens at the point of manufacture. I also want to emphasize that to the extent that there is really...
So how would that work on the background check? I just want to make sure I'm not missing something there.
Yeah, so I think on the background check, if you have a seller out there who wants guidance about whether with respect to particular type of products it's necessary to do that background check, the person can seek a classification from ATF. The manufacturers would be the ones to do this, and this is a way to get a pre-enforcement dispositive ruling from ATF as to whether that's deemed a regulated firearm. And in that circumstance, if you don't like the answer that ATF gives, you have a right to judicial review that will be conducted under a de novo standard about whether this is a covered product.
But if you haven't done that, so you haven't done that, and you truly, take the hypothetical, you truly believe you're not violating the law, could you be charged under that provision?
As a theoretical possibility, I think only with respect to background checks, it's possible you could. I'm not aware of any prosecutions that look like this. And the whole point
is that something the government would do?
I don't think that the government would be likely to charge someone in that kind of situation. And it doesn't look anything like what was happening, where the manufacturers were themselves the sellers, putting these products on the market with explicit knowledge that it was being put into the hands of teenagers, felons, and so forth.
That's helpful. Anything else you wanted to finish up with on that?
So I guess the only other thing I would say is that we think that there is a lot of protection for.
And right there, guys, that gives me a lot of concern because Kavanaugh's more worried about, well, is it affected like this? No. Okay, then I don't care. I think that this is where I kind of get the feeling Supreme Court's going to side with the feds here.
Could well do.
Yeah, I think they're leaning towards that because they're like, well, wait. And they're like, no, we're not going to do that. And they're like, okay, good enough for me.
Manufacturers who are seeking to comply with the law in good faith. ATF is not trying to hide the ball here. The point of the agency is not a game of gotcha to try to criminally prosecute people. There was a very serious.
Ask most FFL holders how they feel about the ATF. Because to them, it feels like a game of gotcha. I can tell you that much. They all think it's a game of gotcha.
Unless you're sending weapons to Mexico.
Yeah. Yeah. Yeah, guys. No. All gun store owners think it's a game of gotcha. So, cute comment from Liz. It's like, yeah, go represent one of these guys getting audited. I'm sure that you'll have a different opinion very quickly.
This public safety threat posed by the explosion and the use of these guns
Hoover.
And crimes. And so the whole point of this regulation is simply to put the regulated industry on notice of how the statute applies in that discrete context and how it's always applied since the statute was enacted.
And on that point, because you had a lot of classification letters that were out there, this was to collect everything and put everyone, as you say, on notice, adding a couple things, as you pointed out earlier, correct?
Right. And so I don't think that this is any vast expansion of the statute. We just think this is ATF's longstanding interpretation with
Some
the addition,
expansion.
with the addition of looking at jigs. But to be clear, that doesn't change the meaning of the statute. It just changes the factors that are relevant under the statute. When
Now
you're
sold without
jigs.
analysis.
Okay, that's helpful.
If you'd like a jig, please order separately.
The question about
Also, we sell them in a
AR-15s.
bundle.
So Judge Oldham
This is
expressed
important.
concern
This is important.
that because AR-15
actually
receivers can be
big.
readily converted into machine gun receivers, that this regulation on its face turns everyone who lawfully owns an AR-15 into a criminal.
That is wrong. So I want to be really clear about our interpretation of the statute. We are not suggesting that a statutory reference to one thing includes all other separate and distinct things that might be readily converted into the thing that's listed in the statute.
So there you go, guys. The ATF has kind of tacitly admitted AR-15s are not readily convertible to machine guns. Now, will they come back into Supreme Court next week and argue the same damn thing or different things? Sure, they will. But right there, this is like I said, it's what the ATF is conceding on things. It's nice to hear, but ultimately I think the Supreme Court's going to uphold the rule. But it's nice to hear the ATF make these arguments, and then they're conceding a lot of points. But I also think they have to concede these, otherwise they're going to get nuked. Because if it got to the point where everything fell into the categories, I think they would get caught overstepping again. So I think they have to give up ground as a tactical consideration here.
And I think that this is also wise the other way around for the Second Amendment advocates for the same reason. I think, for example, Alan Gurrow was very wise when he went to the Supreme Court in Heller.
Yes.
And they asked about machine guns, like concede the ground because you can't necessarily get everything all at once. So you get as much as you can and you live to fight another day. It's a very wise thing to do.
Yes. But in this situation here, I think this helps because they can, Second Amendment groups can point to this and say, well, during the oral arguments, they can, and it's not persuasive. It's persuasive, chat, to say, well, wait, you guys said this literally previously. This isn't an issue, or you said you weren't going to do this, but it is in fact that you are doing it. So it's not a home run per se, but it's a big deal that the ATF is ceding certain points right now, and I would argue this is a big point right here. That statement alone right there is interesting that they would make that argument because previously I don't think they would.
Itself. So the example we give in our reply for a reference
an AR-15.
We're going to back up a little bit
into
here.
A criminal.
That is wrong. So I want to be really clear about our interpretation of the statute. We are not suggesting that a statutory reference to one thing includes all other separate and distinct things that might be readily converted into the thing that's listed in the statute itself. So the example we give in our reply brief is that a pair of pants is not regulated as a pair of shorts if you have a statute referring to shorts, even though the pants could be readily converted into shorts. That's because pants are a distinct object in their own right and they have a separate identity. identity. And the rule itself incorporates this principle by requiring that the regulated object, before you even get to a readily analysis, has to be clearly identifiable as the unfinished component part of the regulated weapon. So what that means is you would have to say, this thing is a clearly unfinished component part of a machine gun, a weapon that's designed to fire automatically more than one shot with a single function of the trigger. But you couldn't say that about an AR-15. That is obviously something that's designed and intended to be used for semi-automatic fire. And the fact that you might be able to undertake certain drilling and machining operations to convert it into a machine gun doesn't mean that while it has this separate identity and is standing alone, it would be regulated as a machine gun. The agency has never held otherwise. This is, again, is the same interpretation that the agency has had all along, and it has never suggested that AR-15 standing alone are regulated machine guns.
They've tried.
Justice Jackson?
So Justice Kagan talked about the problem of the agency potentially taking over what is Congress's business. And I guess I'm worried about the different concern, which is about the court taking over what Congress may have intended for the agency to do.
I love how it's like, I'm more worried. I'm worried about us hurting the government. I understand it's a valuable consideration. It's just interesting. Like, her thing is, well, I'm just worried about you poor ATF people getting overstepped on by Congress there.
Yeah, how will the ATF shoot enough dogs if we regulate them too much?
It's like, oh, you poor ATF boys, I got you there, don't you know? She's like, oh, nobody's thinking about you. I don't know why she sounds like she's from Minnesota, but yes. But anyways, here we go.
In this situation. And so all of my questions, the reason why I didn't really engage in the other part of this is because all of my questions really, for you, stem from that concern. You've phrased the question presented in this case as whether certain items, weapons, parts, and kits, or partially complete and disassembled frames or receivers qualify as firearms within the meaning of the statute. And I guess I'm concerned about this framing because it doesn't seem to account, in my view, for the actual claim that the challengers have made here, which is that the agency has exceeded its statutory authority. And so I'm trying to figure out how we're supposed to address what I think is a distinct question about the scope of the agency's authority vis-a-vis the court to fill out the category of what is a firearm. Are we to conclude that an agency exceeds its statutory authority whenever it fails to choose what we think is the best meaning of a statutory term? Is that
okay? Anytime you want to ask the question would be just fine.
Yeah. Yes. Well, no, and it's she's like, this is where she gets to it here. This is very meandering.
Its statutory authority whenever it fails to choose what we think is the best meaning of a statutory term? Is that how the scope of the agency's authority to promulgate a rule is supposed to be determined? We just compare what the agency believes qualifies as a firearm with what we think qualifies as a firearm. And if the agency has something in its definition that we wouldn't have put there, we say the agency has exceeded its authority.
I was so happy when they got rid of Justice Breyer.
Not right to me.
He came back. He reincarnated. Just say transferred him.
Oh, man.
And if the agency has something in its definition that we wouldn't have put there, we say the agency has exceeded its authority. I think those seem not right to me as the way of figuring out the question of exceeding the authority. And I think it can't be assumed that the agency exceeds its authority whenever it interprets a statutory term differently than we would, such that all we have to do as a part of this claim here today is just decide what we think a firearm is. Can you react to that
Sure. So I think, as in any statutory interpretation case, the task of this court is to determine what Congress intended and what it meant. And we think that we have clearly the best interpretation of the language that Congress used. But the court has said time and again that you don't just look at text, you interpret that text in context.
Right.
And you
But
can
can I
take
just,
account.
can I take you on a little bit of a, let me
Oh
just
my
drill down a
God.
little bit, right? The term we are interpreting, I thought, was a category. Congress has said firearms, right? And frames and receivers, which it defines, the firearms part of it, have to be treated in a certain way. And I think in order to implement this statute, the agency has to look at real world circumstances and determine what particular items fit into that category. I understood the delegation of this entire thing to an agency to be that
Regulate the
test.
guns. Just
That's what
ask the
agency's
question,
supposed to be
please.
doing. We look at firearm, we look at the definition of the firearm, says the agency, and we look at things in the world and we say X, Y, Z, those are in that category. My question is, when the challenge is X shouldn't have been in that category, does it exceed the agency's authority if the court thinks, yeah, X shouldn't have been in that category? Just, I mean, the agency still has the authority, I think. And in Loper seemed to
Oh my
recognize that
God!
Congress may have given the agency the authority
It's
to
still
make
going.
certain calls. Right?
So I think in responding to this
Thank you.
question, it's really
Yes.
helpful to distinguish between the facial challenge here and some of these as-applied applications of the agency's determination of what fits within the definition.
Okay.
I do think that if the court concluded that Congress, in drafting this statute, had, for example, categorically precluded looking at time in deciding whether something's readily convertible, then the agency would be exceeding its authority because, of course, if Congress has said in the statute, you can't think about time,
Right.
then the agency can't choose to do so.
Right.
We are miles away from that kind of situation here because all of the factors the agency listed on their face are consistent with the plain meaning of what it is to readily
So what you would
convert.
have us do is not come up with our list of what items we think should be in the firearm category. Like we have to think about exactly each thing. In this facial challenge, I think you're saying we need to do something more like, did the agency take into account the relevant factors for making the determination of what goes in this category?
That's right, because you don't have any particular products in front of you to examine in light of whether they would fit the definition or not. The only relevant question in this case is the facial question of, does this regulation conflict with anything in the Gun Control Act? And our answer is no. We think that this follows from the plain text of the Gun Control Act and is consistent with judicial precedent interpreting that plain text. With respect to any follow-on questions about particular products, that could all be assessed as applied in light of their specific facts to make a determination about how the factors might cash out in an individual case. But for the frontline question of the agency's authority here, we think everything in the final rule is consistent with the statute Congress wrote.
Thank you.
Thank you, counsel.
Okay.
Mr. Patterson?
Mr. Chief Justice, and may it please the court. This case turns on decisions made by Congress in the Gun Control Act of 1968. First, Congress altered
Here we go, chat.
the common understanding of firearm to include other weapons that may readily be converted to firearms. Second, in a departure from prior federal law, Congress decided.
Yes.
I just need a mental break before we move on.
From Judge Jackson.
Went up for so long. I just need
Okay.
a minute so that we can give it the attention it needs. It's just, oh my God. Just a deep breath, man.
Yes.
All right, so now we'll be hearing from the not government on why this regulation is bad.
Yes.
All right, fine.
Yes. So Ty is saying, did that lady memorize that? A good portion of that stuff she already knows too. I mean, the cases they talk about, she has a lot of notes there. But yeah, you prepare, and you know as much of it as you can.
Yeah, I mean, you will you moot it. You do simulations of it.
Mm-hmm.
So you just practice it like anything else. You get other attorneys, that are familiar with the case, and they try to ask you questions, and
yes,
you try to think of every possible answer, and you read the briefs, and you prep the cases, and you do your job.
Yeah,
and
she's
just really, really good at it.
Yeah, and that's the thing, guys. When you're doing appellate work, you don't. And I've done, like I said, like at the local level appellate work, but you don't go like this. Yes, Your Honor, here's what I'm reading. Yes. Oh, in the case of Dildo versus Baldo, they actually referred to the less filling tastes great principle, where if you're trying to decide things, no, you don't read off as you go. You have to know things. You might have a little bit of notes.
She isn't looking at anything. She knows it from memory.
Yeah, there might be, like a handful of bullet points somewhere, if that, but and if you don't know the answer, you always say, I'd be happy to brief it. I'd be happy to brief it. But yeah, this
doesn't really work at the Supreme Court, but yeah.
Yeah, but in other courts you can do that, but yeah, you're always ready to go. So you're ready now, Kurt? I gave you a little.
Yeah, I'm ready. My soul's prepared. Sorry.
All right.
Decided to regulate only a single part of a firearm, the frame or receiver, and Congress did not alter the common understanding of a frame or receiver. ATF has now exceeded its authority by operating outside of the bounds set by Congress. One, ATF has expanded the definition of frame or receiver to include items that may readily be converted to a frame or receiver. And two, ATF has expanded the definition of firearm to include collections of parts that are not weapons and that do not include a frame or receiver. Some concern has been raised about circumvention, but of course, complying with a statute is not circumventing it. And as this court said in Abramski, which has already been referenced, Congress in the Gun Control Act did not seek to pursue its purposes of controlling access to firearms to the nth degree. And notably, Congress did not regulate the secondary market for firearms. And that secondary market is a much bigger source of firearms for criminals than privately made firearms. There also has been questions raised about the agency's prior practice. There definitely has been a sea change by the agency here. The agency projected that its rule would put 42 out of 43 unlicensed manufacturers out of business. And what the agency said in the Syracuse litigation was they said an unfinished frame or receiver does not meet the statutory definition of firearm simply because it can be designed to or can readily be converted into a frame or receiver. That's the exact standard they've now adopted. Instead, what they looked at was whether critical machining operations had taken place. And to be clear, we have no quarrel with that prior practice. We have raised as alternatives, one, something has to be completely machined, or two, the critical machining operation test. And the latter we submit is more consistent with the statutory language and solves the machine gun problem. Because if you say in the machine gun provision, a frame or receiver is also regulated. And if one hole is all that separates a semi-automatic receiver from a machine gun receiver, it's hard to see how the readily standard would not also be applied there. I welcome the court's questions.
Judge Oldham makes much of the 80% rule that was in stage of manufacture versus what a receiver or an item is capable or can readily become. And we've had much discussion here about readily this morning. Is that analysis or that approach, does it make a difference as to your argument, whether it is the 80% rule or the current readily become rule?
Yes, I think it does, for at least three reasons. One, we submit it can't be readily because when Congress wanted it to be readily, it put it in the statute in multiple circumstances.
Fair.
Two, it has a different practical impact. For example, in the machine gun frame example. So if the standard is readily and the government gives us kind of the paradigmatic example of readily drilling one hole, well, if all you have to do is drill one hole into a receiver to make it a machine gun receiver, it's hard to see how that is not a machine gun receiver. And three, the Congress said the frame or receiver. What Congress did not include in this statute was parts that may be used to convert an item into a frame.
I'm a bit more interested in how the 80% rule operated. We've heard much about the readily this morning, and whether or not that change actually took place and whether it really matters.
Yes, it does really matter. And just the 80% rule is kind of a colloquialism used in the industry. What the governing standard was called the critical machining operations test. And what the agency would do, based on what the definition of a frame or receiver is, the part that holds the essential firing and sealing components of a firearm, would say, we're going to look at that part of the firearm and see if critical machining operations have taken place. And then as a cross-check, there sometimes would be temporal considerations. This is what the agency said in the Syracuse litigation. Temporal considerations were tied to the degree of machining. It was kind of like a lodestar cross-check in a fees case. So they would look at those temporal considerations. But where the difference would be made, and we can see this very clearly in the regulation of AR-15 lowers, and that is the same
I'm not doing that, chat. I don't know what's going
piece
on.
of metal can be considered a frame or receiver depending on what is sold with it. Under the old standard, you would look at the item.
Okay, I didn't do that again. The government's silencing us.
We're just trying to
And
learn,
that's
man.
what Congress did in the act. They said, look at the item itself. It did not say, look at other things that may be used to convert that item into a frame or receiver. And that's what the agency is now doing, for example, with looking at the jigs, because really what is being done is that jig is
So the
being
jig is
regulated,
up?
because the same piece of metal can either be a frame or receiver
But I
depending
thought
on what
readily convertible was in the statute.
readily convertible is in the statute under Part A.
Okay.
It is not in the statute under Part B. So then you cannot, it would be very odd to say that, well, we're going to say readily convertible is a implicit in
For a
every
frame or
term.
receiver, but does the 80% rule apply then to Part A? I'm just trying to understand your answer to Justice Thomas with respect to the 80% rule.
Yes, and again, understanding that we're using 80% rule as a
Yes,
stand-in for
yes.
critical machining operations. No, that applies to Part B. That is what the agency would look at to determine whether something had become a frame or receiver. And if you're,
Counsel, doesn't that give your game away? Once you admit that you need to figure out when
Why doesn't he just bite the bullet and say unfinished receivers are not receivers? Fuck off. That's a distinction. Deal with it. Bite the bullet, dude. I mean, because that's your whole crux of your argument. You're saying if it's unfinished, it's unfinished. Well, then say that and stand there. I understand why he's running around here.
Maybe he just thinks they're not going to go for that.
Well, but that's the whole argument, is that if it's unfinished, it's not a firearm. That's the readily convertible thing, like, because it's not readily, until it's finished, it's not finished.
Maybe he's just trying to find something else that he thinks will be palatable. That's
I
not as
guess. I don't
extreme.
know. I haven't heard this part of it yet, but I'm like getting a little frustrated by him. It's like, dude, you're like, you've only got one argument. It's either finished or it's not. And that, that's the world turns on this. So let's keep going, though.
a finished product. You have to have a standard to decide that. And you're saying the standard has to be something along that goes to manufacturing. The SG is saying, yes, that's just a silent way of saying, has the manufacturing gone far enough to make this essentially a frame or receiver? Can it be converted to be fully functional? That's what they're saying, that the two are doing exactly the same thing. You prefer one because you want to sell frames without a serial number or sell frames that you have to drill a hole in and say, that's not regulated. They're saying a hole is really not a critical component of the frame. Everything else is.
well,
So I'm having difficulty understanding, once you admit that some sort of test is necessary, why this particular test exceeds their statutory authority.
yes, and so.
Since it's only a different way of getting to the same thing. Do I
Understood.
have enough of a frame or receiver to call it a frame and receiver?
Understood. And to be clear, we've provided the court two alternatives. One is that all of the machining operations have taken place. So if you were to say this was a sculptor, all the chiseling has been done, everything's been done, that this can now function as a frame or receiver.
Well,
Our alternative.
you don't disagree that taking a tab off a frame, is that a completed frame?
I don't think taking a tab off, if you could do it with your finger, that's not
All right.
like actually removing material.
So if you have to drill a hole to attach it to something, that's not a
Seriously, just say, no, it's not finished. If I have to do something, it is not finished. This is not like it's either pregnant, the baby is born or it's not born. It's not partway born. Like, I just don't understand why he doesn't just force that. Like, I mean, either like I just dig in on it, man. It's either, you're either pregnant or not pregnant. There is no, oh, well, you're partially pregnant, and then up to this point, you're not pregnant. No, you either are or you aren't. Yeah, he's getting felted by Sotomayor right now.
I wouldn't put it that way.
Well, she's starting to fuck him over because saying, if I could pull this little thing off, does that count? Well, no, that's actually okay. You could probably ban that. Well, if I just have to drill one hole, does that count? Well, you could probably ban that. Like, she's walking him off the cliff. And I don't think he realizes that.
I think he does.
Well, then he should say, but that's when you have to look him in the eye and say, Your Honor, no, it's not finished. No, it's not finished. No, honey, it's not finished. Listen, Justice Honey, it's not finished.
Don't do that.
I wouldn't call her Justice Honey, but
don't do that.
Judge Hot Lips.
No.
Going to a match reference. All right, I'll be right back, Kurt. I gotta step away for a second.
Okay.
Completed frame.
Well, this is where the difference between the two alternatives that we have given the court comes in. Under the first alternative, drilling a single hole would be what would make it cross the line. And the government admits that sometimes drilling a single hole can be the difference between a semi-automatic receiver and a machine gun receiver. And a machine gun receiver is much more heavily regulated than a semi-automatic receiver. So the notion that
all
just
y'all
one
in
hole
chat
separating
need
something
Jesus
from another item is somehow absurd is clearly not the case. But the alternative we've given you is the critical machining operations test. And that is different from the government's new test because A, it's not conflicting with the statute by taking language from another part of the statute that's not there and putting it there, and where the government represented in the Syracuse litigation in 2021. We can't do that.
Let me come at it. Oh, I'm sorry,
Yeah.
Chief, please.
What is the purpose of selling a receiver without the holes drilled in it?
Well, there's some individuals, just like some individuals enjoy like working on their car every weekend, some individuals want to construct their own firearm. So the purpose of selling it is to allow,
I'm sorry, go ahead.
is to assist and provide individuals with material with which they can do that.
Well, I mean, drilling a hole or two, I would think doesn't give the same sort of reward that you get from working on your car on the weekends.
Well, I would encourage the court to read the Vasquez brief. This is not a easy thing necessarily to do, and particularly the Press Democrat article cited there where the reporter engaged to show how easy this was, and in fact show that he couldn't actually do it. He had to engage friends to help him complete this that were expert in the firearms. And even once you have a complete frame, it's not a trivial matter to put that together. There are small parts that have to be put in precise locations. And that reporter, that he couldn't put it together from the completed frame. So it's not clear that it is clearly not a trivial.
I once took a Glock completely apart and put it back together
that.
just for fun.
Well, I don't know the skills of the particular reporter, but my understanding is that it's not terribly difficult for someone to do this. And it's certainly not terribly difficult to take the plastic piece out. Is that part of the gunsmithing?
Well, the plastic, the part.
Yes, just say yes. It's all part of the acquired skills and knowledge base. Just say yes, Pete. Come on, buddy.
Parts that are blocking the rails in the product that's been highlighted, that has to be taken out. It's recommended that you put it on a drill press vise and use a drill press with a specialized bit to take that away. And Polymerate explicitly recommends against using a Dremel. They say that could damage the product. And I know we don't have any particular product at issue here, but the point is that with what Congress said is that we want to regulate the frame or receiver itself. And there's got to be some point. There's going to be a line.
I'm suggesting that if someone who goes through the process of drilling the one or two holes and taking the plastic out, he really wouldn't think that he has built that gun, would he?
I don't know what that person would think, but I think he would. It's not a simple proposition. Even the individuals that the government cited that took 21 minutes to put something together. It wasn't counting the time for the person to acquire the tools, learn how to use the tools. This person was a mechanic, so they knew how to do these things. Or the time to learn how to machine the object. That person spent 2 hours watching instructional materials before starting to put that item together. And even after that 21 minutes, the person had done it incorrectly and it needed to be repaired.
I'd like to circle back to Justice Sotomayor's question on B.
Yes.
I take that one position might be it has to be a complete frame or receiver because there's no indication of readily converted the way there is in A.
Right.
Right. I got that argument. But I think you've suggested that now we accept that there are incomplete frames or receivers that count. This is indeed an artifact noun. And if that's true, well,
artifact
all,
noun.
True?
Well, we've given our
what exactly is an artifact
noun?
noun?
Be complete, but we've given an
I
alternative
don't know.
argument.
I almost what in artifact.
Does this just mean a term of art, or does it mean something else? What
Let's see
exactly is an
here.
artifact noun?
An artifact noun. Well, okay, so a noun's any object, okay, but what is a synonym for artifact noun? Oh, antique, relic, antiquity, curio, evidence.
That's just a synonym for artifact.
Yeah. Yeah,
I need artifact noun as a phrase. What is an artifact noun? I need a grammarian.
Yeah, I don't. Yeah, it doesn't even know. Google is like saying, yeah, no, it doesn't have no idea. I don't know. So, yeah, call Nick. He'll know his creative writing.
Okay.
That, okay, it could be an artifact noun, but if it is, the test should be critical machining and not readily converted.
Let me press on the first argument. Yes. Why wouldn't this be an artifact noun in this statute? Given A, which does suggest incomplete things, can count. C, mufflers and silencers. D's, other destructive devices, which don't have a traditional receiver. I think the examples we've been given are guns and pen guns and things like that. Why wouldn't that be?
Is a Baldo a machine gun?
Not throughout the U.S. Code. Congress was using an artifact noun.
I would think the inference would be precisely the opposite because Congress put that language specifically into those neighboring statutes, words like converted or words like collections of parts. So it would be odd to say that in this particular place where Congress has taken a special care to use that sort of language, when Congress wanted that language to be applied, to say, well, we're just going to infer that it also applies here where Congress did not put that language. And I think it could, again, as I've said, it could wreak havoc with the firearm laws because there are a lot of things that can be readily converted. A traditional rifle can be converted to a short-barreled rifle in minutes with a hacksaw or by swapping in a shorter barrel.
Fair.
If this concept, readily converted, Congress only put it into specific places, and we can see in the machine gun.
Yeah, that's probably the answer you should have known the whole time.
Instead of readily converted. So we need to be very precise here. And in terms of why we would pick critical machining operations instead of readily converted, if we're looking for evidence of meaning, if we're not going to say it has to be completed, well, one evidence of meaning was what did ATF and the industry working together over a period of years arrive at? And what they arrived at was this critical machining test because it does not pose these same problems as readily converted would, potentially with other provisions of the code. And it also is more consistent with the statute by not importing readily into a place where Congress chose not to put it.
Thank you.
Doesn't appear in the statute. It seems a little made up, right? The critical machining test. I mean, your other test, I think, has the problem of pulling a tab off the front and saying, okay, now it's a frame or receiver, but it wasn't before you pulled the tape. But the critical machining doesn't really come from the statute. It's just sort of a way of allowing for de minimis exception, right?
Well, I wouldn't say that, Your Honor. And first, we wouldn't, even under our primary test, I think it's, if it's machined, so, if you think of the sculptor, when everything's been sculpted, if something is put on to protect it or something and it just has to be pulled off, I wouldn't call that machining. So I think it's once all the holes have been drilled, all the material has been removed that requires tools to remove. That would be our primary test. But then under the secondary test, so that it would come from the language of frame or receiver. And I think you would say, okay, this is an artifact noun, but then what does that artifact noun mean? We have to still determine at what point something is a frame or receiver. And we think the evidence of meaning of the agency and the others in the industry who are very keenly interested in this question, working it out over a period of years and saying, okay, here is this test that we've come up with, this critical machining test. It's much better attested than readily.
So would you say that it's like the ordinary usage, now everybody just understands based on longstanding practice that this critical machining test is the point at which frame or receiver?
Correct. And it's not that we're deferring to that, but that's the best evidence we have of what this means.
In ordinary usage, an object that is created to perform a function may still be called by the name that's attached to that object, even if it is not completely functional. Isn't that what this gets at?
I don't believe that this is what gets at, and there are two provisions here.
Well, before you walk away from that, let me give you an example. Okay. Suppose I see that my neighbor is restoring a classic car, but he's taken out some critical parts. And then someone says, well, what is that? And I might well say, well, that's a 1957 Thunderbird, even though you couldn't drive it and it would take some work to make it do the thing that it was originally created to do. So isn't that the essence of your backup argument? The thing must still be such that one would call it a frame or receiver, even if it is not fully ready to be functional as a frame or receiver at this time.
Yes. So our primary argument is it would have to be, and so I think you could think of the situation with a car and you ask your neighbor, can I borrow your car? And you give him the car with the engine taken out. They would probably say that's not a car, but also the backup, yes, is that at some point, something is a car, even if it can't currently perform that function.
So what exactly does the critical machining test involve? What does that mean? To explain it to somebody who, to a lay person.
Yes. So a frame or receiver is basically the part of a firearm that holds the components that allow a firearm to function. So the firing mechanism, the trigger and such, and the sealing component that makes sure that the barrel is sealed off so that the round goes out of the barrel and the energy from the explosion doesn't go elsewhere. So what the critical machining operations test was, okay, we're going to focus on the parts of the frame or receiver that either have the holes drilled or material removed that are going to hold those parts. And we're going to see, have those operations been performed to some degree? And if they have, we're going to say that's a frame or receiver. And what's important is that this solves the one hole and the AR-15 lower problem, because the critical machining operation for that machine gun receiver would be drilling that final hole. So until that final hole is drilled, or at least indexed, as the government has indicated, that critical machining operation has not taken place. But if the question is readily, then it would be hard to see, well, how it could be readily in this context and not readily in the machine gun context.
So you presented the court with the critical machining alternative, and you say you have these two alternatives. The agency has presented yet another way of going about this. Do you concede that under a facial challenge like the one that you brought, your task is actually to demonstrate that your alternatives are the only permissible ones under the statute?
Well, I think it's under a rule of party presentation. We've presented the court with the alternatives that have occurred to anyone. So I think these are the best alternatives.
So you see the question as what is the best alternative? And the court is just supposed to say, we have three options here. Which one do we think the best? The agency didn't pick the best. It's rule stricken.
Well, I think we actually don't have that. I think our burden is to show that the agency's is wrong. Maybe we don't have the right interpretation. But if their interpretation is incorrect, then they're asking the wrong question.
But by incorrect, you mean that they don't have the authority under the statute to reach that? It's inconsistent with the statute?
Correct. If frame or receiver does not include items that may readily be converted to frames or receivers, then this rule is beyond their authority, regardless of what frame or receiver does mean. So they've gone beyond their authority. And so, we've presented the courts with two alternatives that we think are better interpretations. But the key point here is that the agency's interpretation is incorrect.
Do you
Oh,
believe
dear.
that a weapon that has been disassembled, a firearm, a gun that was
That
once
sounds kind of
fully
uncomfortable.
operational,
Yeah.
everyone would agree was a firearm, it's disassembled, as sometimes happens, maybe even after a crime. Is that still a firearm or no, under your view?
Yes, and for two reasons,
Okay.
if I could give it. So the first reason is that we'll have a frame or receiver. So that's what Congress put in the statute to ensure
In my
that would
hypo,
be
the
a
frame or
firearm.
receiver is not in the box.
Oh, then no, if you don't have
It's
the
not.
frame or receiver, then no, it's not a
Okay.
weapon.
So all that matters really is B, the frame or receiver.
Well, that is how the statute is structured, and part of that may be due to statutory history. So before this statute, the definition was any weapon that is designed to expel a projectile by the action of an explosive in any part or parts of any such weapon. And I think we
But
can
what's all that language doing in there if all that matters for the purpose of the definition is that it has a frame or receiver?
Well, and so what I was going to say, Your Honor, is that Congress was working from that background, and they said, okay, we're going to alter the definition of A to include readily convertible weapons, and we're going to alter the definition of B instead of including every part to focus on a particular part, the frame or receiver, and it's the frame or receiver of any such weapon. So it really could, so I think that explains, that's why it's structured that way. It's maybe not the most straightforwardly structured statute, but it could be the frame or receiver of, and then insert A instead of any such weapon. That's really how the statute is structured.
I'm
The frame or
sorry,
receiver
could
is
you
B.
clarify for me what you mean? Assume that there's all the parts of a gun and a weapons kit with all the parts of the gun, but the receiver or the frame has a hole missing. So that's the weapon
Right,
parts kit.
right.
Is it your position that under A, assuming we were to find that readily convertible does include some drilling, some holes, et cetera, just like a starter gun to make it a weapon, would that be covered under A?
I don't think, I think whether it would be covered would turn on the interpretation of B. If the court accepted our backup argument,
Okay.
and
So
that
what you're taking out of B, readily convertible, and also taking it out of A.
no, we're not taking it out of A because, and it's because of what A was meant to cover. And that is these starter guns that practically were guns. They had handgun frames,
You have
but the
no-
barrel had
You
to
have
be.
no quarrel with the proposition that the agency can, within whatever the statute limits it to do, to determine what makes a completed or nearly a completed frame or receiver.
I'm not sure I understand the question, but we have no quarrel as the alternative with we presented with the critical machining test and the hypothetical Your Honor presented with a single hole.
Thank you,
that
counsel.
likely would meet that test.
Anything further? Thank you, counsel. Rebuttal,
Is it?
General?
Thank you.
Too
Mr.
short.
Chief Justice, I want to begin with the question you asked about
very short.
why manufacturers would leave
Not
these
good.
holes undrilled. You said, what is the purpose? My friend responded that it's to create a kit
Yeah.
that hobbyists can put together. I think that that's a questionable proposition, given that if it only takes 20 minutes, the hobbyist is probably not going to get his money's worth and won't actually have the experience of building a gun. But I also think it's contradicted by the facts on the ground, because what the evidence shows is that these guns were being purchased and used in crime. They were sold to be crime guns. There was a 1,000% increase between 2017.
These are made to be crime. These are crime guns.
I think the government's going to win. I think you have to just score it based on the oral argument.
Oh yeah, no,
Like,
no.
when there was
they
that
got-
silence, when he stopped speaking and no one's talking, like no one's breaking in with questions, he doesn't have anything more to say, and then they get the Q&A, and like no one really has any real questions, and they're like, okay, we're just kind of done. I think the problem at the end of the day is that there's just not enough daylight between what he's proposing and what the government's proposing.
Yeah, no.
There's just not enough. There's just not enough there, and so or as I would say sometimes, he's trying to slice it too thin.
Yeah,
like there's just not enough a distinction for it to matter. And
I
so I think the
also
government's
don't
going to
think-
win.
I don't think he stormed on hard enough. Like I said, you have to hammer that distinction. Say, look, it might be thin, Judge, but once again, it's difference between pregnant and not pregnant. It takes one little thing to happen. You know, it's one little thing between a fire and not a fire. Like, I'm trying to, like, he didn't want to just say, yes. You don't understand. This comes down to that little bit of a distinction.
And he also didn't seem as prepared as Solicitor General. It's Solicitor General, like it's not the first time she's heard the questions, which is why, like you guys said, was she reading? No, she's not reading. She's just like prepped. She's done her job. She's prepped.
Yes.
And the other guy, it's like the first time he's ever heard the question. That's a good idea. I never thought about that.
Yeah. Well, and when you're wrong, even when they're right, you still figure out a way to go back to your point. But yeah, it's like, you know, it you know, when we like, I guess he's trying, like, and it's almost, he's acknowledging like the idea of substantial compliance. Like, if you told me to build your house and I built like 95% of it, well, I've pretty much done most of it, so therefore it's a house. Like, no, you'd sue me in court and say you didn't build my fucking house.
Right.
Like, you know, oh, you forgot, like, hey, you painted 95% of my car and there's a big primer spot on the trunk. Well, or it's like, it's only 2 inches wide, a 2-inch by 2-inch square. You know, you go into court and be like, look, it's mainly a car. It's mainly painted. It counts. No, you would never do that, because all you have to go is, like, literally all it would take is me to get the paintbrush out and go, done. Does that mean have I fully complied? No. And that's why I think you can make the argument of, no, you cocksuckers, it is either finished or it is not. The baby is born or it is not.
I don't think the problem.
Well, it's.
Yeah, I don't think the problem here is that he doesn't specialize in firearm cases. I think the problem is he just didn't do enough prep.
Yeah, I don't think
he didn't do enough moots. He didn't get enough attorneys together to ask enough questions. He didn't think about this from 8 different ways and have all his ideas slaughtered to death.
Just like that. You know, because these guys aren't gun people, then fine, use common law principles. Like I just said, painting a house.
Or become a gun person. Just become like knowledgeable.
Well, you don't even have to.
Just
you
prep.
Don't have to be. Well, because the clerks aren't gun people. Yeah. But you could say Justice Jackson. You know, Justice Ketanji Jackson Brown. You know, listen, if I painted your car and there was a 2-inch square missing, and all I had to do was take a paintbrush, and would you believe the body shop saying, "Oh, it's close enough," and take care of it yourself? Would you think you have a painted car on your hands? No, you'd be suing me immediately because I haven't completed the work, even though it's 99% done.
Right.
Like I said, there's ways you can argue this that get to the point. Yes, J-Rock's right. Your kid used cocaine or it did not. Yes, either it does or it doesn't.
Something like that. Yeah.
Yes, your stress is here or it's here. There's no in between.
You went to hedonism too, or you didn't.
Yes. Yes. You either followed strapping burly black men on Instagram or you did not.
You either went to a Denny's and understood what you ordered,
or you didn't. Oh, but yeah, that's.
Or you're a cop.
Yes. You're either a cop or you're not. I don't know if you heard 2.0. She just said attaboy.
Excellent.
So, yeah, I mean, I just think this could have been argued so much better. There's just, listening to this now, it's like, wow, there's so many ways, because those judges would all understand the idea of painting, like a car being painted. You don't have to get into like what a gun drilling a receiver. Just make it easy. Yes, I either answered the question or I didn't.
Yeah.
All right, we'll let her finish this up and run out the clock here for 5 minutes.
And 2021 in the number of these guns that were recovered as part of criminal investigations. And it makes perfect sense, because the whole reason why you would want to get your hands
on one
of these unserialized, untraceable firearms is if you are a prohibited person or you want to use that gun in a crime. And more fundamentally,
or because I just don't like you knowing what I own and it scares the shit out of you, therefore I want more of it. Maybe that's why I want them. Because I want them.
Mentally, if there is a market for these kits for hobbyists, they can be sold to hobbyists. You just have to comply with the requirements of the Gun Control Act. Someone who is lawfully allowed to possess a firearm and wants to build it can purchase that kit if they undergo a background check. And so if there is a market for these products, they can operate under the statute. The evidence shows that actually the market for ghost guns essentially collapsed after this rule was permitted to go into effect, which I think just underscores what was evident all along. The reason why you want a ghost gun is specifically because it's unserialized and can't be traced.
Yes, you understand the point. Nobody wants to go waste time buying a gun with a 4473. That was the appeal. That's the appeal of why I have that, because you don't know about it.
I wanted a ghost gun because there is a scary ghost haunting my amusement park.
Yes, you want to kill him. Yes. Yes, 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 Liz. Lizzie, you understand it. You understood the assignment. There's a reason why I want that. There's a reason why I'm going to sit there probably in a week or two for a couple hours in my grinder and sit there with the flap disc and grind down that 3/4 inch pipe to make it fit in the 1-inch pipe. Yes, there's a reason why I'm doing that. Yes, there's a reason.
Please take note that Sean just said he's going to use grinder to get the 3-inch pipe down to a 1-inch pipe. So, yep, that's fine. No problem. Good.
God damn you, Kurt. God damn you. Fuck. God damn. Felted, let's go, etc. But yes, that's Mr. J says, why is the Second Amendment the only one that's bastardized like this? Because it's the one they understand. Because the purpose of the Second Amendment, we're the only country that has a reset button written into its founding document. And this is the reset button. It's the only button that acknowledges, hey, you might have to start killing government officials at some point. We're going to allow you the ability to do that. That's why it's bastardized. The government doesn't like the fact people can kill them very easily. And in America, it's very easy to do it. So, yes, there's a reason why it's the bastard child of the Constitution. Yes, it's mega-based, or Kurt Felting is mega-based. That's James says, excuse me, what about the 1st, 4th, 5th, 9th, or 10th?
A lot of amendments bastardized. That's fair.
Yes, they get, yes, but you don't have the ACLU come run into your defense in a Second Amendment case. A lot of people will bail. Yes, and the 4A has been shredded, but not to the same level the Second Amendment has. Yeah, yeah. So, anyways, we're going to finish up here before I embarrass myself more.
On the question of a frame or receiver, Justice Sotomayor, you asked questions about exactly what standard governs here. And I think it's helpful to break down the interpretive question into 2 points. The first one is, this is an undefined term in the statute. Does it require the weapon to be functional? We think the answer to that is no. If you are missing a single hole, then you can clearly recognize that as an unfinished component part of a weapon, and it is readily convertible to function, and that fits within the plain dictionary definition of what a frame or receiver is understood to be, no different than a bicycle missing pedals or a tennis racket that is sold unstrung. We have a picture of this on page 34 of our brief, what these frames and receivers look like, and it's hard to know what else to call them because they look exactly like the principal structural component of a gun. But that just raises the follow-on question. Okay, if it doesn't have to be functional, exactly what standards should you use to measure when it is a frame or receiver regulated by the statute? And there are good reasons why ATF focused on whether it can be readily convertible. First, that's most consistent with how Congress has approached this issue when it has defined terms under the federal firearms laws. That's the standard that Congress itself uses to mark the terrain of what products are regulated. Second, there is a consistent agency practice here of applying that readily converted standard. My friend several times tried to suggest that the 50+ years of agency practice instead focused on whether it has reached a critical stage of manufacture, but that's ignoring the actual elements cited in the classification letters. They looked not just at what had been done to the gun, but what steps remained. how much time it would take to perform those functions, what equipment you would need to make that functional, what kind of skill you would need, and whether there are other parts. None of those elements go to what has already been machined on that particular frame or receiver. Instead, they are centrally relevant to whether it can be readily converted to function, just as the agency has said all along. For a third reason, that means that this is a standard that is familiar in the law and familiar to industry. I think it's really notable here that we don't have the major gun manufacturers suing us about this final rule. And the reason for that is because this readily converted standard.
Because the major gun manufacturers don't do this. They don't sell partially completed guns. It's a massive liability for them to do that. They wouldn't be selling these. They'd have to have a hole in their head. But Remington, Smith & Wesson, the major gun companies don't do this, but like other gun companies do. This is something for small organizations that'll do it.
Is the one that has governed their conduct ever since the Gun Control Act was enacted. That also means that there is a stable body of judicial precedent and agency practice to draw on here in further answering concerns about whether particular types of products will be regulated, which I think Justice Kavanaugh also answers some of the concern about how the regulated parties will know whether their conduct falls within the scope of the law. Finally, in thinking about respondents' primary argument here, which is that a single undrilled hole is enough to exempt a product from regulation, I think the court doesn't have to blind itself to the practical ramifications of that rule. The agency's interpretation reflected in this rule is the status quo. It is how the law has been applied over 50 years. And if this court now says that one undrilled hole is enough to exempt these products from regulation, then that is going to be a sea change in how the Gun Control Act is implemented. At that point, it can't serve out its function because all manufacturers everywhere could simply exempt their products from regulation through that simple expedient. And that means that going forward, all guns could become ghost guns. This court said
the horror of it all,
Emily, that you don't have to interpret a statute to be self-defeating like that if there is a plausible alternative construction. Our construction is not only plausible, it is the best reading of the statute, looking at text, context, purpose, and history. So I'd encourage the court to say that and reverse the Fifth Circuit.
Thank you, General Counsel. The case is submitted.
The regulation is staying in place.
Oh yeah, we're toast. We're toast. It's Dunsky, 100% done.
Yeah,
and you know, honestly, like, yeah, well, the big gun companies don't do this. The big gun companies don't do a lot of damn things, like listen to consumers. So yeah, and Trump one has a great point. Till 1968, guns did not need a serial number. It's very true. I have a couple of unserialized guns. I have a gun like was made in the heart of 1937. They didn't put a serial number on it because it cost too much money. So serial numbers were part of industrialization and quality control, but there was never a requirement for it. So, yeah. Manny says, read the briefs. We might at a point coming up here, but
I was reading the briefs. I know
you did.
I spent like an hour and a half on them. I kind of skimmed them on some part, but yeah, I read some of the briefs.
Yeah.
There's some good arguments in there, but the way that he actually went about arguing, it's like
this was a poor like this wasn't a very good arguments tonight.
No.
So 10K says serial numbers are only really required for the manufacturer tracking and warranty. Yeah, it's just it's bullshit for home guns. Yes. Logical Bystander says, how common is a serial number to solving a gun murder anyhow?
Really common.
Well, I mean, they track a gun back through the line, but usually it's like, well, who did you sell? They go back a little farther, go to the guy who sold it, and he's like, oh, I sold it to this guy, and then it goes backwards. But normally it's like, oh, we found DNA on the gun, or we found fingerprints on the gun. But it's never like you used your gun to commit a murder, and then they track it back to you, and then they find everything else. It doesn't happen like that, because that's the way a lot of people seem to think. Oh, well, serial numbers and microstamping will help. It's like,
well, microstamping is bullshit.
Yeah,
because the technology just doesn't work.
Yes. Jim says my Mauser doesn't have a serial number, but it has an eagle on it. It's like, there you go. Yes. Bot says any crime specifically can get solved the serial number. I don't think so, specifically. Sergeant
Depends-
Jordan says here in
I mean, it
Cali.
depends.
you-
I mean, yeah. I mean, depends what you mean by soft, but yeah, I mean, gun tracing is done all the time, and guns are matched to where they came from. So it's often an important lead as part of it. Let's say that's
yeah.
fair.
But that's what I mean. Like, it's never like, oh, you used a gun and they immediately tracked this and, oh, this is Kurt's gun. Kurt did this. No, they're usually like, how did this gun get here more than. Sergeant Jordan saying, Callie, you need to register to get a 3D printer? Really? That sucks. But yeah, that's the next step.
All right. Well, I guess I'm going to sign off for now, but it's been interesting. I'll be covering this later on my channel once it's up on yeah, because I like it with the synced transcript. So I'll be covering
yeah, I think so. I think it helps. But anyways, thanks for being here, Kurt.
It was fun. I'll talk to you soon, and
right.
hopefully we can chat more. And let me know if you want to get together for that gun build. Sounds like fun.
Yeah, no. If you want to join me on we'll do that coming up. It should be fun. Guys, Kurt on Civil Law, thank you for being here, Kurt.
Late,
Take
bye.
care. Yep. Good night. Oh. Stacy says, what, registration for a 3D printer? I think so. Is Kurt in Ohio? No, Kurt is in Tejas. The place formerly known as Texas. Anyways, chat, we got some stuff to get to real quick here. Let's Go Brandon says for $4.99, that's not Clyde Fund. Well, it was Clyde. Bibliophile with the B1B Lancer, the bone on his like little avatar saying, gifted 5 subs. Thank you very much for your support. I appreciate it. Tech South says, Preligar was a law clerk for Merrick Garland. Yes, she was. She also then became a law clerk for Ginsburg and Elena Kagan. When Kagan was a justice, then became a clerk for Ruth Bader Ginsburg. Yes. Jeff says the Second Amendment permit private ownership of nuclear ICBMs. You can afford them, yes. I would argue, yes, they do. And Seller says, wait till they find out what killed Shinzo Abe. Yes. And Young is saying, I wish I understood what a ghost gun was. Basically, it's anything you can build at home that's unserialized. They consider a ghost gun. But I will say it's a creative name. It's a creative name they came up with. It's better than assault rifle. They did a really good job of naming that one. So I hope that answers your question. I hope you're still around. So like this gun right here that I made does not have a serial number. It's unserialized because I made it entirely on my own. On Hunch Dirty Roofer says, my 2 favorite law-related YouTubers. Why? Because y'all forsake views for pure con lawtism. That's all I ask for. Well, thank you. I try to. Sleazy says this is like the 5th edition 40K rules, except they don't yell. Yes. Yes, it's very, very straightforward. You notice her at the end. She's like, that's why I refer to my friend or colleague. You don't go, that cocksucker, that faggot. You don't do that. You don't do that there. You do it very respectfully. Trump one says, you ever go to the Bria Gun Show? Not since before I was in college, but back when like SKSs were like $80. So no, not recently. Been 20 years, I think. Yes, Guru for Hire says if you need a manufacturing jig, it's not a conversion. I would agree. Karate Cat Mom says my groomer used a Dremel. Yes. And then Ammo's Currency says ask Matt Hoover what he thinks. Yeah, very true. Very true. Zero Fucks has been a member for 13 months. Says the ATF approves of Dremel usage on dogs. I'm sure they do. The Content Lasagna is saying how many of these are getting replaced by Trump in his second presidency? Oh my God, that would be great. Well, Sotomayor's got a lot of health issues, chat. She's not that old, but she's got diabetes really bad. She's got some other blood disease. She's got a lot of health issues. So hopefully, but overall, the liberal wing's in a lot better shape than the other side. So like Alito's getting up there. Obviously, Clarence Thomas is up there. We need to, the problem is though, we replace them with like another Kavanaugh or another Barrett. Not so good. We replace them with a Gorsuch. Hell yeah. Fatty Caddy says for $2. You know what I color, Sean, and it ain't brown. Yes. Content Lasagna is a member. Thank you for the support. KJ's been a member for 8 months. Says the ATF thinks drawing on metal is a gun. Yes, they do. They do. Even if it's out of spec, they think it's a good. They think it's a gun. Cedar Rose says, beware of Indian scammers calling to get you to buy Clyde coin. Really? I can't believe that's happening. It's not the same. Only true Clyde coin has been certified and approved by Clyde. Yes, very true, chat. And hold on real quick. Hey, Clyde, come here, buddy. See if he'll click clack. Come on, bud. Here he comes. I hear the click clacks. Come here, Papa. Come here, puppers. Oh, he didn't even come around the corner. Come here, buddy. I can see your tail. Clyde, come here. Come on. Come on. You want some food? I got a treat for you. Come on. Want a treat? I got a treat. His tail's still thinking about it. Come on. Come on, bud. Oh, Clyde's not coming in right now. Man, he's being all skittish lately. He'll jump up on me when I'm not on camera. Got to figure that out. Let's go. Brandon for $4.99 says the perfect medium between all storms. Boredom. Been there 6 months. Been there, done that. It's been a member for 6 months. Says I didn't know Sean was on Grindr. Thank you. 2 scoops of Destroyers. Been a member for 24 months. Thank you so much for that support, man. I appreciate it. October of 2022, man. God, that goes way back. That's way back. It says, thanks for dropping by, Kurt. Yes, thank you, Kurt, again for dropping by. Hope you're still out there enjoying your night. 10K View says, thanks for coming to this topic tonight. Been a member for 9 months. Well, thank you. GB is saying for $5, just watch Marine Gun Builder do a live. He was there live at the Supreme Court. He thinks they're going to win. I mean, I assume he thinks like we're going to win. I don't. I mean, guys, that's. Tam says you need to work on your recall. He does recall fine everywhere else. But I just don't see it happening. I mean, who's this guy anyway? Let me see here. We're gonna have to check this dude out, and we'll be nice to him. But like, Marine Gun Builder. If he just went live or something like that, I guess. Oh, he does all kind of Glock stuff. Okay. I'll have to watch this recap later, but so I'll take a look at this later. He looks like a good channel. How many subs this guy got? Let's see what he's got. Let's see if we can help him out here. Oh, he's got 62.9 subs. Well, still, guys, give him a look if you're interested in Marine Gun Builder. But yeah, I don't think we're gonna win, chat. Like it was too fine a line. He didn't bite the bullet and just say yes, this is exactly what we're doing. And he just kind of gave it up. So I don't think it's going to work. I'd love for it to work, but I don't think it's going to work. It's just, and Kurt brought up a great point at the end. When they're just like, it's all silence, that's a sign. Like, I've had that happen before in oral arguments. You're dead. Like, dead air is the worst thing in the world when you're making oral arguments. So. Well, he's one of the biggest P80 builders. Okay. Yeah. If you build a P80 wrong, it'll run fast. Yes. Yes. How do you build a gun with crayons? I don't know. Yes. A job well done says, another win for the toe. Yes. The toe can't stop winning. And Mr. J says, I appreciate you doing these streams and reading chats. Well, of course. It'd be boring if I didn't. You're a real OG and I appreciate you. Yeah, no, thank you. I appreciate that. But yeah, it's if I don't read the chat, it's kind of boring. Kind of sucks. It's just me talking. Bob Masavo says, go to Freedom Crew University for Marine gun builder and other great instructors. So I would say that, but I probably can't show the page because YouTube will probably nuke me if I do. LS16 says these arguments were not first time quality. Yeah, they weren't the best. Red King says this was a win the same way that Frank's motion was. Well, I'm assuming this guy wrote a better motion than the Frank's motion. And I'm assuming he could write a better Frank's motion too. So, but I get your point. I get your point there. It just wasn't very good. Oh, okay. And Stabby's saying, I've got a buddy who works with him on shit. Use code MGB for 10% off at a Freedom University here. Should still work. Well, there you go. Does Marine Gun Builder enjoy wind chimes as well? Not sure. You know, and guys, here's the thing. I hope we win. Just not counting on it. And remember, they're going to get to the point of, you know, their goal is to turn everything into a registered receiver. So just remember, that's their game plan. Ultimately, this is just the next big step. Before you build your next one, go buy 1 or 2 build videos from Freedom Crew University. I'll take a look at what they got, especially if they got like G3 series, like how to build a G3, because I need to know where to weld in the full auto stops. Yeah. For this argument, you go hard. Yes, if you have to work on it, it's not complete. Yes. And that's the thing there. And I guess that's the point I was trying to raise earlier, chat. You got to bite the bullet and say, yes, they're all unfinished. Therefore, they are not finished and not receivers. Done. End of story, Judge. You have to ride that line. You have to dig in on that position. And when the judges say, well, what if you have to pull a tab out? It's still not finished. Like I said, it's like if I painted your car and left out this big a square on the back. You would all sue me for that. I would say, fuck, your car's pretty much painted. If I threw you a bucket of paint and said, fix it yourself, you would get really fucking mad. Isn't a magazine a registered receiver? Don't give him ideas, Dornan. A GB says Heller showed up outside. He thinks they won too. That's Dick Heller. He is the person behind Heller versus District of Columbia. You know, praise be unto him. Allah, may Allah bless him and Alan Gura. Many blessings. I don't get that vibe, guys. This is not the same vibe as the bump stock case. You know, this isn't that. I'd love to say it is, but it's not. It's not. I'm not feeling it, Chad. I'm not feeling it. I'm willing to be wrong. I hope I'm wrong. Travis says a safe without a lock is just a cabinet. Yes. Dornan says that's hands-on site. Okay. Content Lasagna says, is our wife a registered receiver? Well, it depends on how you define receiver, but possibly. Do they have registrations at hedonism too? Well, there are some tattoos that can be worn about a spade. Oh. Yes, Hail to the Break says the main issue is eventually you get to the point where everything's a gun, and that's what the government wants. Because their biggest problem is they spent all this time doing receivers as the way you define firearms or the registered items, where in a lot of countries, the registered items are pressure-bearing parts. So like mainly barrels. Barrels are the hardest thing because they're the hardest part to make. That's the hardest part to make for any gun. Barrels, reliable barrels, safe barrels. Registering receivers isn't really the that's kind of meh. Anybody can make a receiver. You can make it you can make an AK receiver out of a shovel. So yeah, I understand you there. Trump is saying, how can the court change the definition when Congress made the definition? Well, they're not changing the definition. They're just it's the same definitions. They're just saying because of the change of technology, this definition is they're adding to what counts under that definition. I mean, it's yeah. I get what you're saying there, but they're not. The court will get that around there. Stabby saying, I sent you a link if you're interested in building an FGC-9. Well, shit. I do. I want to build one. It'll be fun as fuck. I can use a Glock 17L barrel instead of all their barrels. Ooh, that's awesome. I didn't know you could do that. I thought I saw your comment earlier. I'm like, hell yeah, I'll do that. Although the problem is they sell those kits with the barrels in them, but yeah, that wouldn't be so much easier to headspace and use. Yes, there's going to be 4473s in Home Depot. Yeah, even with EDM barrel making at home, it's not easy. Yes, that's correct. So we'll see. Yeah, Dagamore says print out the rifling jig and use the salt water and a battery charger for the FGC-9. Yeah, I've thought about doing the homebrew EDM work, but I might build one with an actual good barrel on it. I think that'd be a lot more fun. Logical Bystander says, I'm more concerned about a thug with a stolen high point than a ghost gun, but the courts aren't ready for that argument. Yeah. Although, remember, High Point's the pride of Ohio. High Point and Anderson Manufacturing and Palmetto State Armory have done more to take care of Americans being armed than anybody else has. And Fair Frozen says, one's off of MAF Corporation. Yes. Yes, and remember, guys, if you guys are looking for wind chime kits and wind chime accessories, maf-arms.com. Use the promo code POTCRIM, and you get 10% off your order. And as I said before, in honor of the VanDerStok ruling, Matt will still put on your invoice. He will put some lipstick on, and he will put it between his lips and put an imprint on there for you of his lips covered in lipstick, because he wants you to know how much he loves you guys and cares about you guys and appreciates your business. He's promised me that, chat, so he has to do it. He can't back out now. That's at maf-arms.com. High Points for when llama is too fancy of a brand. Well, no, it's High Points there when a Lorison or a Jennings or a Jimenez is too fancy. Oh. 10KB says, what is a high point? A high point is HI-POINT. If you Google them, they are basically blowback pistols that don't really have any locking mechanisms, and the only reason why they operate successfully is because they have a zinc cast slide that is so huge and heavily weighted that the gun stays in battery safely. And it's a gun you could buy for $130. It's a 9mm pistol for $130. That's why. They also sell carbines in 9mm, 40, 45, and 10mm. For the longest time, they were the only 10mm pistol caliber carbine you could buy in America. High Point is the Bayliner of guns. Yes. It's the Bass Tracker of guns. It's the Bass Tracker of guns. Oh. It's a Glock on a budget. Yeah. The 10mm is only $225. Yes. But it's only single stack. That's the problem. High Point only sells single stack magazines. So you're kind of fucked when it comes to that. And you can buy the Stendo mags, but they're goofy looking. All right, chat. So I think we're all caught up here. Like I said, fingers crossed, but we'll see. Okay, you're saying, when is a justice a justice? While they are a lawyer or a judge or neither? Yeah, You mean like when do you call them that? I mean, well, they're always Justice. Like Sotomayor is always going to be Justice Sotomayor. If I ran into her at a party, I'd say, "Oh, Justice Sotomayor, how are you doing?" Now she might say, "Oh, call me Sonia," but that's up to her. But no, you would address her as Justice Sotomayor, and if she retires, she's Justice Sotomayor. Bob says, "How many 10mm rounds do you need?" I don't know. I'd like to get an MP10. Get one of those MP5s in 10mm. Those are pretty dope. The 5 and dime, as they call it. The Vanguard King says Demolition Ranch probably buys more high points than anyone else. And he has a dedicated playlist on getting them not to fire. True. But also Grantham has had a high point, and torture testing it broke the slide in half very quickly. So it's, yes, high points are generally pretty tough guns and will work. Stabby says Matt tagged everyone in his Discord with the complaint documents. I'll take a look at it all. Yes, Tech Heavy's my pronouns Emperor. Oh. Lady La Sandra is saying, I met Sotomayor. Yes, the most humble person I know. I mean, yes, generally, I mean, like, I got to hear Scalia speak when he came to my law school. Yeah, they're pretty reserved people when they're out in public. And I'd say in general, they're pretty reserved people. They're not going to be people like me. Why didn't I say Kwisatz Hader? I can't say it. I don't know how to pronounce it. I can't do it. Kwisatz Haderach. Or Haderach. Kwisatz Haderach. I don't know. Is that some anime thing? I don't understand it. Okay. Cover Legal Mindset real quick. No, we're not going to talk about Legal Mindset tonight. I watched his show. He did a pretty good job. But, you know, when it comes to Legal Mindset, all you could think of half the time is just...
Legal Mindset! Legal Mindset! Legal dick suckers, more like it.
Anyway, shout out to Andrew. Hope you're doing well, man. He read the whole Baldo. He read the whole Baldo thing. So... Say, it looks like you're drinking paint water. No, I'm drinking a little bit of tea tonight. Ban assault cars, right, meow. Yes. Dune is almost anime. I don't remember that name from Dune, but it's been a long time since I read it. And I have not watched the new version. I have not watched any of the movies, the new movie yet. Yeah, just as Sean and Kurt would have parties on the SCOTUS steps. Oh, yeah, it'd be awful. It'd be awful. I'd be awful as a justice. I'd be like, the fuck you I'd be like, counsel, the fuck you talking about? What do you guys want me to play? What the hell? Oh my god, okay, yes, Nico, I see this now. I will play this. This is funny as hell. Dune is very overrated. No, I think Dune's very good. Play Dune, yes. All right, here, this is funny. Justice Martin, why did you moon the Solicitor General while she spoke? No, it'll be Justice Martin, Justice Martin. Why'd you say I will not withstand this faggotry anymore before you stormed off the bench? Yes, Justice Martin, what farm scrub are you reading during oral arguments? Be like, yes, you were. What were you doing that was so important there? Well, I'm sitting here. Yes, I was reading the Farms. Oh, there we go. Like any other justices, you trying to hear? Yeah, I'd be looking over at like Sonia or Katanji, be like, "The fuck you guys on right now?" Yeah, I don't care. I'm the new guy. All right. Anyways, we're going to end on this video chat. This is hilarious. I think, we'll watch this real quick and then we are going to take off from there. Wait, where did this go? I downloaded it. Where the fuck did it? Hold on, chat. Yeah, it's in my. It's right there. So where the hell is it? Killing me. All right, here. You guys are thinking it's going to be an 8-1 opinion. Oh my God. Talk about copium. Talk about cope. Copenhagen. Holy shit, chat. Do not cope like that. Do not cope. Do not cope. Yes, Justice Martin, did you fall asleep during my brief? Yes, I did, because that's how boring it was. I'm in D. Why? All right, there we go. Let's try to find this again, because it's not popping up for me, chat. It's getting frustrating. Why is it not showing up here? This is getting a little annoying. I downloaded the video. Okay, let's see. Here we go. I think this will work now. Let's try it. Let's try it. Are we doing a local stream? Not tonight, chat. All right, I think this will work now. Can you guys hear this at all? Let me know if you guys can't hear this. If you guys are ready, here we go. You guys can't hear it? Damn it. Seriously, I downloaded it and it's like, okay, well, find it in your video files. All right, well, I'm looking for it and it's not showing up. It's going to be 9-0 in the release of press release with all their wind chimes they put together as a group. Oh my God, you guys are like cope lording it. Cope lording it like bosses. Oh, there we go. All right, here we go.
Legal mindset. Legal mindset. Legal dick suckers, more like it.
Yes, that was Nick Israel. There we go. You guys had to have heard that. That was pretty. Whoever made that is a king. That's hilarious. And on that note, chat, I think we're going to wrap it up. Yes, another all-time banger for the toe. Yes, chat. With that said, I think we're Oh, actually, hold on here. Yes, Fair Froze is saying, did you hear about Matt's bar complaint from cheese pizza lover Cody being rejected? No, not yet, but I kind of figured that was going to happen. And then That's a Shame says, this is just like a family vlog where the parents exploit their children into participating. Except you guys like Clyde. You want him so much, I had to make him an emoji. I can't please you people. Anyways, That's a Shame. Glad you're here. Good to see you. Oh, did you hear about Stoney's bar? Well, it's only Tuesday night, chat. I can't encourage drinking tonight. All right. So, guys, it's going to be... Yeah, like I said, if it could be, I could see it being 5-4. But, yeah. Anyway, like I said, we'll find out what happens. So, guys, thank you for being here tonight. Enjoy it. Everybody enjoy our time. Tomorrow night, we might do a doubleheader. We might do something and do members only. Not sure. I might be going out tomorrow. So, it's going to all depend. I'll let you guys know ahead of time. I'll leave a comment here in the locals. And then, guys, if you're new, Thursday night, every Thursday, we do the live show. Every Thursday night at 9:30. got a lot to talk about already. There's a bunch of stuff going down. The guys who hacked and stole the dossier of JD Vance stuff and hacked some things in the Trump campaign have been indicted. The people who were throwing paint and crap on pictures over in Europe, a couple of them are going to prison, and it's very interesting what happened from there. Hannah Reid got denied a new trial. A big BLM guy got sent to prison for being a scam artist. Oh, who could have seen that coming? The ADL has redefined anti-Semitism to be everything. Sarah Boone's case is going along interestingly. The Springfield complaint against Trump, there's been movement in that. And the Deadspin is getting their asses blown out for that case involving the kid with the Kansas City headdress on. So that and a couple other things we'll be getting to as we progress, and that'll be all Thursday at 9:30, chat. Bob says members only. What's the point of locals? Well, we do both because some people want to be members here. They've given memberships here, and we also have locals. So we're doing a little bit of both. So just a little bit of both. We help everybody gets a little piece of the action. That's why. Because, Bob, we have over 1,000 members here right now, and I have to do something for them. And otherwise, I'd feel like a big piece of shit ripping them off. Yes, the albino one. Yes, Zero Fox. You can only pick on the grays here. Yes. So, guys, we're all set, and I will catch you guys tomorrow. Until then, just remember, just because you did it does not mean you're guilty. And remember, it's still not finished. If it's not finished, if it's unfinished, it's not a complete receiver. Good night, chat. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that came